Good morning. You're good? You're good? Okay.
You're carrying a lot. You do. Carrying, later than
Is there any speaker? Hey, Chairman, how are you? Hey, good morning, folks. Good morning. If I could have your attention for a minute, we're about 4 minutes out from starting. So if you're back in the back of the room, come in and fill in some of the chairs we've got here. And we're going to start right at promptly at 8:30 so we can get through everybody's testimony and get everybody back to work. Morning. Thank you for hosting us here in Blue Ridge, and we're going to go ahead and get started. My name is James Burchett. I'm the chair of this study committee. I'm from Waycross, Georgia, and this issue has brought out a significant amount of folks in every venue we've been to, and this is no exception. And so I want to thank you all for coming out today and participating in this very important issue. Just for your planning purposes, I'm going to run through the agenda real quick and tell you how we're going to run through today's meeting, and then we'll call to order and get started. So we'll have a call to order invocation. We're going to do opening remarks. I'm going to have the committee introduce themselves, and we'll have a welcoming from the local representation with Representative Johnny Chastain, and he'll recognize the local officials. We'll have some stakeholder group present, and then public comment, and then we will adjourn. The intention is to be complete here at 11:30 today. We're going to try to take one break in between public comment and stakeholders, depending on how time is. So I would appreciate if everybody would be clear and concise with your testimony and help us move along today. So very much appreciate it, all the folks that are here today. And I'm going to ask Representative Mac Jackson to give us our invocation, and we can call to order.
Thank you, Mr. Chairman. Shall we pray? Heavenly Father, we just thank you for this day, Lord, for you giving us another day, and we're greatly appreciative, Lord. We ask for your wisdom, your guidance, your leading as we go through these hearings, Father, and we'll always give you the praise, honor, and the glory. In Jesus' name, amen.
Amen. Thank you again. As I said, this is a very important issue that we're undertaking here. We've had testimony at each and every for the last 2 weeks at our stops in Gage, Georgia, and Habersham that are very passionate about this issue. Folks are, and we recognize that, and so we want to come here and hear what Blue Ridge has to say about the issues and what we're talking about at the General Assembly. I know there is a lot of anxiety with regard to this issue, and I want to try to put everybody's minds at ease here. I can strongly say that with conversations with this committee, private property rights are paramount to the General Assembly and the folks on this committee. And you have a right to be anxious with regard to some of the language in the House resolution for this subcommittee and with passage of some of the legislation. So I recognize that, and if we did not recognize that, I think it would be foolish. And so we're here to hear what you all have to say about this, and very happy to be here and very happy to have conversations with you. It's been a fantastic visit so far. We had the opportunity to be hosted by one of your local fisheries here, and we see why everyone is passionate about this. We have something that is very unique in the state of Georgia here in North Georgia, and I recognize that, and we do not want to soil that, certainly. So I'm going to ask from my left to right for the committee members to introduce yourself, and we'll start with Chairman Gunter.
All right, thank you. I'm Stan Gunter. I represent House District 8, which is Towns, Union, and most of White County, and I'm your neighbor to the east.
Representative David Knight. I represent District 134. That is parts of Spalding, Lamar, and Monroe County.
David Jenkins, Representative House District 136, that's south of Atlanta in the Noonan area. The Flint River borders my district and pretty close to the Chattahoochee as well.
Again, James Burchett, District 176. I'm from Waycross, Georgia, so I'm from the Blackwaters of South Georgia.
Al Williams, District 168, Liberty County. That's another part of the Blackwater, and we really can travel as the crow flies.
I'm Representative Mac Jackson. I represent District 128. That includes Washington County, Hancock County, Glasscock County, Warren County, a portion of McDuffie, and a portion of Baldwin County.
All of Georgia.
Most of it.
I'm Rob Leverett. I'm from District 123. I live in Elberton and represent Elbert County, Wilkes County, Lincoln County, part of Madison, and a few precincts in Columbia County. So I'm from, my district's not bordered by, but I actually have both sides of the Broad River, and then the Savannah River, which is now Lake Russell and Lake Thurmond on my east. So we got a lot of water in my district too. So I'm very interested in that topic we're discussing, and very pleased to be with y'all here today in this lovely setting.
Well, thank you, committee. I also want to thank the folks at Old Tacoma Farms. This place is near and dear to my heart. We've had the opportunity to come up here for the past 3 years. Well, actually 4 years prior to COVID. I keep forgetting about the COVID year, and have been able to watch this place grow. And this is just a class act and a great venue. So thank you for hosting us. I'm going to ask Representative Chastain to come to the podium. I want to tell you guys have a great delegation here, and you have a great representative in Representative Chastain. When I asked if we could come up here and speak to you all, it was immediately a yes. And what can I do to make this meeting happen and work for the committee? And so I want to thank you, Representative Chastain, for all the hard work that you've done in this and putting this together, because this is no small task. And so thank you very much. I'm going to ask that you recognize the local officials here in the room and give a word of welcome. Okay, thank you, Mr. Chairman. Appreciate it. I know our whole community appreciates Chair and the committee for being here in our town this morning. It's a very important issue. Blue Ridge is the trout capital of Georgia, and I know from the lineup and the folks that we've got speaking today, hopefully we can give the members some good points and some things to take back with them. I want to thank Peter Knudsen and the OTF staff. First of all, where's Peter? What a great job they've done, as Mr. Chairman's already said. They've done a lot of work here. This was a tavern yesterday, I guess, wasn't it, Peter? But they've done a lot of work. Appreciate everything that they've done. If you get a chance to come back, if you want to play golf, this is one of the best golf courses in the Southeast. You can hike here, you can fly fish here, you can do anything here that you want at the farm. So take some time and enjoy that while you're here. Also want to thank the chamber for the breakfast this morning. I know Christy's here, and I'm going to have Christy say a word here in just a second for the chamber. I know Trip Martin here. I want to call out Trip just for 1 second and thank Trip for all that he's done for us in our preliminary meetings and helping us. He hosted a couple of things for us, and I really appreciate that. I want to recognize our mayor who's here this morning, Miss Rhonda Thomas. Rhonda, come on up here. I'm going to get you to introduce yourself and say a quick word for us.
Thank you, Representative Chastain. Thank you all for being here. We appreciate you coming to Blue Ridge, Fannin County for this meeting. It is a very important meeting. I see a lot of fishermen, property owners, people in this audience who I know are very passionate about what you guys are here to discuss and study. Fishing is a sport that is enjoyed by all in this area. The Georgia Constitution gives us that right to enjoy the waters, and fishing is an important thing for everybody in this room, as well as property rights. Fishing is a sport enjoyed by all walks of life. To Georgia's ex-president, Jimmy Carter, and First Lady Rosalind. I know they have fished the waters in these areas up in North Georgia. And Bill Oyster, are you here? So I know you have a long history with them as well, making fly rods. And you'll hear from Bill, I'm sure, later on today. He is very well known in this area for his business downtown, which you should stop by and check that out. Fishing is important to everyone. There are over 100 miles of trout streams in Fannin County alone. Some of the more prominent fishing streams include the Toccoa River, Noontootla, Rock Creek, Fightingtown Creek, Big Creek. So there are many different sized creeks, which I'm sure you guys have recognized that from being in this area. The Toccoa River, of course, it's more of a navigable river, which with the passing of House or Senate Bill 115, I believe the term navigable would apply to the Toccoa. But some of the other streams, I know that DNR has looked at different ways to define what is navigable. And some of our other smaller streams, such as Fightingtown, are they truly navigable? And I think that's where we get into the issue of property rights. Who has the right to you would literally have to walk up miles of private stream in order to access many of the farms or different properties that have access to the Fightingtown. Just to give you a little history of myself, I'm an ex-school teacher. I taught for 10 years. I a real estate agent. I own my own real estate company here in Fannin County. When I first started selling real estate, I was very young, naive. I didn't really comprehend property rights a lot. So one of my first sales was on the Toccoa River, and I sold a house that it sits right on the Toccoa. So I got a call one day from my customer, my client, and there was a big controversy next door. There was a fisherman who had come down the Toccoa on a john boat, had stopped in front of the property, which he had every right to do, and was fishing. But he took it one step further. He stepped on the riverbanks on this guy's private property. Well, DNR was called. This was years ago. Had to be called. He called me and was very upset at what was going on next door. So that was an eye-opening experience for me, understanding that, property rights with the Toccoa River, you have the right to fish, but you really don't have the right to come up on this property. When we look at properties such as Fightington Creek, my husband grew up on a farm. It's 150 acres. We have about over half a mile of Fightington Creek, and we own on both sides. So, in fact, one of the fishing companies that may be here today, they lease this property from us in order to have private fishing groups. But I would truly be alarmed if I'm walking on our property and I saw someone walking up the creek that was not supposed to be there. That would be alarming to me, not to mention the liability factor. So, I feel like you have a tough task ahead of you in looking at what is navigable and also protecting the rights that the Georgia Constitution gives us to fish and enjoy the waters, along with protecting property rights. So you have a tough task ahead of you in making this more definitive, and I don't envy you at all. So, because it is very passionate on both sides. But thank you again for being here. We appreciate all you esteemed representatives and appreciate everything you do. And more than that, we appreciate you asking us to speak so that you can hear from us. So thank you. And thank you, Representative Chastain.
Thank you, Rhonda. Appreciate that. We also have our Commissioner Chairman with us today, Jamie Hensley. Jamie, you want to raise your hand? You want to say anything or say? Okay.
All right, I'll stand right here.
We've got folks watching. We're going to have to get you up there. While he's making his way up there, one thing I skipped is, so the purview of the committee is to study the issue, right? And what comes out of the committee is not legislation, it's a recommendation. What do we do from here? The recommendation may be that we study further, we find some clarity by naming or delineating what is able to be fished and what is not able to be fished by the public. So it's not legislation that comes out of this committee, it's just a recommendation to the body. Very good. Sorry, I just wanted to insert that.
So I'm Jamie Hensley. I'm a commissioner here in Fannin County. Reiterate what Mayor Haight said, but at the same time, when I was mulling this over in my mind on what to say and how to approach this, my dad's words kept coming back to mind. I grew up not far from here, and whenever we wanted to fish on somebody's property, we used a common sense approach. We went and asked them, "Can I fish on your property?" And if they said no, here come the respect factor. I respect your answer when you said no, and I will not. But in the event that you won't allow somebody, would you just let me know, and I'll be glad to come and fish. But I think that's what we've got away from is truly just common sense. I mean, when did we get away from communication and respect? That's what we got away from. If I want to go up to Mr. Olnby's place, I'm going to call Mr. Olnby and say, "Mr. Olnby, can I come up there and fish?" And if he says no, if you decide to allow me to, I'd appreciate that. If not, I understand. But I think it can be as simple as that. Just to be honest with you, we can beat our heads against this rock all day long, but I think at the end of the day, it comes down to common sense. Can I? Yes, thank you. If I can't, thank you. Communication and respect. It goes a long way in the world, and we've got away from it all. And that's what we need to get back to is communication and respect. That's all I have to say. Thank you.
Thank you. Thank you, Mr. Chairman. Thank you. We also have Christy Gribble with us, Chamber President. Christy, thank you. Thank you for breakfast. You want to say something?
Good morning. Thank you, Chairman and Study Committee, for being in our community. So Christy Gribble, President of our Chamber of Commerce and CVB. So we manage the visitor economy in Fannin County. You are going to see one of the most beautiful fall days once this fog clears. And Peter, I think I want to have my next meeting here. So this is my hometown. I grew up here, left, came back, but I grew up fishing with my dad wherever he would take me. Can't say I fish anymore these days, but we are the trout capital of Georgia, as many of you probably know. Our visitor economy here is bustling, mostly due to outdoor recreation. So in 2020, it really doubled as people came swarming here to get outdoors. Around that time, we started a campaign called Keep Blue Ridge Beautiful, and I've got each of you a little bag in the back. So as you leave, please grab that. The idea is to pack it in, pack it out when you're hiking. Among many other things, we joke. It's not really funny, but we do joke. Our emergency services sometimes get calls from people who put in at the dam on the river and end up in McKaysville and their car's not there. So it's not a lazy river. So I say all this, we try our very best to educate the visitor, but they just don't always know. What we are doing is around sustainability for the future of our beautiful community. And I know you've heard from Emily OMB and the folks at Noontootla Creek Farms. What they're doing with conservation really does matter. Protected land, U.S. Forest Service, that matters. We have such an amazing community that people want to come to. But we have so much along the Toccoa River that is available for those who want. So also in your little bags that I've got at the front, we have 2 river access maps, one for the upper Toccoa and one for the lower Toccoa. So upper Toccoa being technically below the lake on the Noontootla Creek farm side, and then lower Toccoa going towards the Ocoee River. So 60 miles of the Toccoa. On our maps, we show access points and fishing spots. So I just thought this might be helpful for you, again, in your bags. We have a very, very special community, as you know, and I just hope you'll consider what makes this place special as you make your recommendations. So Johnny knows how to find me if there's anything else I can do to help.
Thank you. Great job, Christy. Appreciate it. Thank you. Almost done, Mr. Chairman. Yes, sir. We have our sheriff that came in, Mr. Dane Kirby. Dane, appreciate him being here. I know Justin was here earlier too to help us out, so appreciate y'all being here, Dane. I got him. I see him back there. Also, we have a local school board member with us, Mr. Terry Bramlett, right here on the front. Terry, thank you for being here. We have a retired senator here with us. Where's Judson? Judson Hill, Senator Judson Hill, here on the second row. I think he's going to speak in a few minutes. And we have our majority leader of the Senate just came in a few minutes ago, Mr. Steve Gooch. Mr. Majority Leader, you want to say anything or?
Just glad to be here in Johnny's district.
Great. It was foggy this morning. We're glad you're here. Again, thanks everybody for being here. We appreciate it very much. And I'm going to turn it back over to the chairman. Thank you again. I appreciate it, Representative Chastain. All right, so where are we at now? We're going to go into we're going to start our testimony. Thanks for the welcoming words from the local officials, and thanks for your interest in the issue. I know this is very near and dear to your hearts in your community. So first off, I'm going to ask that DNR Scott Robinson come up and speak. And I've asked DNR to come speak to just give us a lay of the land. The DNR is not making a recommendation one way or the other to the committee. We've asked DNR to give us as a resource, be a resource to the committee and tell us how the problems they're having. One of the issues that we're trying to solve is this. When you have a private property owner who spots someone on their property fishing and DNR is called out there. You've got a upset private property owner. You got a fisherman that is either knowingly or unknowingly on private property who's then upset for being, it's a contentious situation. And then you've got a DNR agent out there trying to make a determination of the law on the banks of a creek. And so one of the issues we're trying to clean up is so that the DNR agent doesn't have to make a subjective determination of what the water is right then and there, navigable, non-navigable, which makes the determination of whether the fisherman can be there. So we're looking for clarity to say, hey, you can't be here, you can be here, is what I'd like to see come out of this committee. And so we've asked DNR to come and tell us what is the state of the state with our rivers and waterways. And I also want to make this clear. There is a unique difference in our trout waters and our South Georgia waters. The river that runs behind my house looks nothing like any of these waterways that you have here. Nothing like them. Much broader, much slower moving water, much deeper. So I want everybody, I feel like everybody in here knows that, but I think it needs to be said. There are huge characteristic differences of the waters here in North Georgia and the waters in South Georgia. So with that said, Scott, please continue.
Thank you, Mr. Chairman. I'm Scott Robinson. I'm the Chief of Fisheries for the Georgia Department of Natural Resources. Certainly appreciate the local host here. What a beautiful place. And so thank you for having us. A little bit about fishing in Georgia. Fishing is very important to us. It's part of our culture, part of our heritage. It's socially and economically important, as you all know here, certainly in this area. Fishing generates about $1.5 billion in retail sales each year here in Georgia and supports around 15,000 jobs in the state. So fishing is very important to us. It's important to who we are. There's over 1 million licensed anglers in Georgia, and nearly 200,000 people have trout fishing privileges. In the past 10 years also, DNR has received about $85 million in federal sport fish restoration funds. That funding comes from excise taxes on fishing equipment paid for by anglers, and it goes directly back into supporting public fisheries, hatcheries, and all the things that we do to support fishing and fishing access in Georgia. Some of those things that my team works on, in the past year, we've stocked about 9 million fish in Georgia, all over the state. About 1 million of those are trout, and about 4 million of those support some sort of riverine fishery. We've built and currently maintain over 250 boat ramps around the state. Many of those on rivers and streams, but also on reservoirs. We spend about $1 million a year of that federal money. We're actually required to spend that on boating access according to the law. So that's, we spend a lot of money on boating access. We monitor fishing populations to set fishing regulations. We look at genetics. We investigate fish kills. When somebody has a spill or something causes fish to die, we investigate those kills and try to determine what's causing that. We operate public fishing areas. We get about 800,000 visitors a year to our public fishing areas. So again, I think that speaks to the importance of fishing here in Georgia. We also do a lot of outreach and education to try to teach people how to fish ethically and responsibly, which of course includes not fishing on private property without permission. I'd like to talk a little bit about the trout anglers that we serve here in our trout program specifically. As I mentioned, almost 200,000 people have trout fishing privileges in Georgia. So we're serving not dozens of people and not hundreds of people, but tens of thousands of people with our trout fishing program. That's a very different scale from the private outfitters. And we certainly cannot provide that type of experience and don't try to. We do try to provide good fishing on public waters so that people they're not flying in from exotic locations to fish here. They're driving up with their families from Dalton or even Savannah or Waycross, Greensboro, Madison, all around the state. They drive up here to enjoy the public waters and the public resources and teach their kids how to fish. some of those kids will learn to love fishing and love trout fishing, and they'll go on to become customers of some of these trout outfitters that are here today. But first they have to learn, and they have to learn somewhere where their families can afford to take them. Fortunately, we have a lot of public waters and public land here in North Georgia that allows that to occur. So again, fishing is so important. It's already been mentioned one time here today that fishing is enshrined in our state constitution. Somebody thought it was important enough to put it in the state constitution that Georgians have the right to fish and hunt, and that fish and wildlife will be managed by law for the public good. That's absolutely critical to allowing us to do what we do and creating these opportunities for people to enjoy the great outdoors here in Georgia. So the state, according to the law, has ownership of all wildlife. That is just so that we can manage it for the public good and invest public resources into managing those wildlife populations. So the state's wildlife resources are managed in accordance with sound principles of wildlife management and for the public good. Now, the law defines the rights of adjoining landowners in navigable and non-navigable streams. Navigable streams, stream which is capable of transporting boats loaded with freight in the regular course of trade for the whole or part of the year. And then there's some qualifications to that. And the rights of owner of lands which are adjacent to navigable streams extend to the low water mark in the bed of the stream. Now, non-navigable streams, which to my knowledge include all the places where private trout outfitters currently operate. On non-navigable streams, the owner of the land adjacent to the stream owns to the center of the stream bed and controls the right to fish there. There's really no question in the law currently about that. It's just what's navigable and what's non-navigable. Historically, the Georgia legislature has described navigable streams in many different ways. They've set toll rates on streams that were considered navigable. They've made it illegal to block passage on navigable streams and rivers. And they've even named commissioners to oversee improvements and clear snags and make way for people to be able to navigate and access public waterways. The U.S. Army Corps of Engineers and the federal government also have several lists of navigable waters in the state. One of those is the Toccoa, and there's certainly some gray areas in there on what should be considered navigable by the state or by federal waters. So again, the state has invested millions of dollars collected through license fees and federal funds to establish fisheries, establish boating access, produce the sport fish that are stocked to support those fisheries. And then, of course, last year, SB 115 was passed that affirmed the right of Georgians to fish on navigable streams and continue to keep those open. So as DNR, as managers of the public resources, we sometimes have to make determinations on what we consider as navigable. And we've used many different factors over the years to do that, but we're always using those factors to weigh against the state law. So would this stream, what would allow it to support commerce or freight, boats hauling freight, since that's what the law states. So we look at current state and federal law, we look at historic uses, we look at old court cases and attorney general opinions. It's a very complicated issue, or it can be. We also look at stream characteristics. For instance, one we've been looking at is mean annual flow, cubic feet per second of water that flows in a stream. Generally, we've considered anything greater than 400 cubic feet per second to be navigable. We think that's navigable, and that encompasses nearly all of the boat ramps that we've constructed over the years are in streams greater than 400 cubic feet per second. There's a few in South Georgia that don't quite meet that, but as you mentioned, the waters in South Georgia are quite different. So 400 cubic feet per second, I do have a map that we can put up that illustrates that and shows people exactly where those waters might be. Anywhere between 200 and 400 cubic feet per second can go either way. We've seen that in both ways, and we've looked at historical documents and historical use and other factors to try to determine where those fall. And generally below 200 cubic feet per second, I don't think there's anything in the state that would be considered navigable there. There may be a few, but, and obviously these decisions are up to the legislature, has the final say on that. So we're certainly not trying to get ahead of the committee or have never tried to get outside the bounds of what the legislature set for us there. So again, thank you for hearing me out. I hope we can come to some clarity for our anglers, our hardworking law enforcement officers, and of course these good folks that operate private fishing operations. That concludes my remarks.
Thank you, Scott. Anything out of the committee questions? This is the third time we've heard Scott, so I think expect everybody's got their answers from it. You got it memorized yet? We appreciate it. All right. I'm going to move on to Mike Worley. Questions from the audience we'll do after the committee. Oh, we've got the map back here. We can put it up in the back, Scott, where people can check it out while we're at recess. All right, Mr. Worley, please introduce yourself and give us your testimony. Thank you again.
Yes, sir. I appreciate everybody being here. It's an honor, as always, to speak to this distinguished group of legislators and this really interested group of folks in fishing issues here in the state. My name is Mike Worley. Mr. Chairman, thank you again for the opportunity to do this. I'm President and CEO of Georgia Wildlife Federation. I'm here today to lay out the background, why we're here, what started all this, and pretty much that's about it. I'm here to, but first, let me tell you a little bit about Georgia Wildlife Federation. We've been around since 1936. We're Georgia's oldest member-supported conservation organization. We provide leadership services and advocacy on conservation issues across Georgia, and we are a proponent for the professional science-based management of our wildlife and natural resources. We've long been a leading voice in Georgia's efforts to protect and enhance our natural systems and to protect and enhance our rights to hunt and fish. In early 2022, a landowner demanded, via a lawsuit against the state, that Georgia DNR law enforcement and local law enforcement officials ticket anglers for fishing on a portion of the Flint River that had been judged by Georgia DNR to be navigable and had been publicly fished by generations of Georgians. GWF stated our position that navigable streams should be available to the public to fish. We fully expected to pursue this position through the legal proceedings. On March 27, 2023, the Georgia DNR Commissioner signed what we believed an ill-advised consent to that lawsuit, laying out a formula for which anyone with property along any of Georgia's navigable streams could likely establish their own claims of owning exclusive fishing rights. On March 29th, 2023, the last day of the legislative session, the Georgia General Assembly passed Senate Bill 115 that corrected the mistakes made in that consent agreement. Senate Bill 115 is 3 sentences long, and it simply restates what has always been the case in Georgia. Navigable streams are open to the public for fishing. It does not in any way enable the public to access private property. Private trespass was illegal before the passage of Senate Bill 115, and it's illegal today. Time has proven the General Assembly was correct in passage of Senate Bill 115. The urgency was indeed there, as another lawsuit, almost identical to the first, has since been filed seeking to prevent the public from fishing the navigable Flint River. I appreciate you all being willing to engage on this issue. I thank you for studying this critical issue. It seems often our hunting and fishing rights are always under assault these days, and it's up to us to pass them along to future generations. It's great to hear people talking about that fathers and daughters and mothers and passing that along to their kids. But let me be perfectly clear. Georgia Wildlife Federation is in favor of the public being able to fish on navigable streams, just as we, the public, have always been able to do. We are not, however, advocating for expanding what is navigable. We are not advocating for expanding fishing access onto those streams that have been judged non-navigable in the past. Mr. Chairman, I've truncated my remarks significantly, but it's a real pleasure to be here. Thank you so much for the opportunity.
Yeah, thank you. Thank you, Mr. Worley. Any committee questions? Thank you, Mr. Worley.
Thank you.
All right. Ms. Lipscomb, April, are you here? Will you introduce yourself and give your remarks, please?
Yes. Thank you, Mr. Chairman. Good morning, everyone. My name is April Lipscomb. I am a senior attorney with the Southern Environmental Law Center. So I'm an environmental lawyer with a specialty in water law. The last two meetings we had, I went over the history of fishing and provided an overview of the public trust doctrine and how that evolved in America and in Georgia. My focus today is going to be a little bit different. Last week we heard a lot of concerns from members of the public about the possibility that Georgia could adopt what some of the Western states have had in terms of stream access laws, where they've allowed the public access into non-navigable streams, the wet boot kind of laws. So I thought today it would be helpful to explain briefly how those states are justifying those kind of wet boot laws, and then explain how Georgia is different. And just to be clear, too, there are only a handful of states that allow public access on non-navigable streams. The big ones are, Montana, Utah, Wyoming, New Mexico. So this is not a majority rule across the United States. But there are two common threads between those states. And the first is that they have all adopted the prior appropriation doctrine for their system of water rights. And I'll kind of get into that in more detail in a second. And the second common thread is that they all have constitutional or statutory provisions declaring that all water in the state belongs to the public, or that all water in the state belongs to the state on behalf of the public for the public's use. So that is enshrined in their constitutions or in their statutes. So to back up a little bit, there are two primary systems of water use rights in the United States. So in the eastern part of the country, we typically have a riparian system of water rights, or regulated riparian system of water rights. So in that type of system, water rights attach to riparian land, or land that is adjacent to a water body. So to gain those rights, the landowner must own the property adjacent to a waterway. Under that system, a riparian owner may reasonably use the water that's adjacent to their property, as long as that use does not interfere with the reasonable uses of other riparian landowners. The riparian owner does not actually own the water in the watercourse. They have a right to use that water. So that's what Georgia has. We have a regulated riparian system of water rights. And the regulated just means that we've also adopted like permitting requirements and some regulations that clarify what those water rights and duties are. Out west, it's a little different. They have the prior appropriation doctrine. So water rights in those states are granted based on when a person uses water for a beneficial use. It's basically a first in time, first in right system of water rights. So the earliest user of water that puts water to beneficial use gets a priority in the use. And beneficial uses of water are things like irrigation, drinking water, industrial use, recreation, things like that. So if there's not enough water in a waterway, for example, the senior rights, the people that have the first rights, they can use all of their water rights. And then people down the chain may not be able to use all of the water that's been allocated to them. Unlike in a riparian system, water rights are not attached at all to ownership of land. So that's an important distinction. Out west, water rights are not attached to land ownership, whereas here they are. Again, the states that allow the public to fish in non-navigable streams also have those constitutional or statutory provisions establishing that water belongs to the people. Just to give you a couple of examples. So Montana, that's probably the state that has the most, I guess we'll call it kind of angler-friendly access laws. Their constitution says all surface, underground, flood, and atmospheric waters within the boundaries of the state are the property of the state for the use of its people and are subject to appropriation for beneficial uses as provided by law. So again, you have that public ownership of water enshrined in their constitution. This is also true in New Mexico. In Utah, they have a state statute that says all waters in the state, whether above or underground, are declared to be the property of the public. So again, that public right of water. So what these states have done is they have expanded the public trust doctrine to apply not just to navigable waters, but to all waters in the state, to non-navigable waters. And if you'll remember from the last two meetings when I went over the public trust doctrine, traditionally in America, that applies to navigable waters only, because the states took ownership of the beds of navigable rivers in trust for the public upon statehood. So this is an expansion of that public trust doctrine out in these sort of Mountain West states. And they have concluded that the public has the right to use water regardless of whether the stream itself is navigable or non-navigable, and regardless of who owns the stream bed, sort of based on those two concepts. One aside, Colorado is sort of the exception. So Colorado also has the prior appropriation doctrine. They also have a constitutional provision, but they've gone the completely opposite direction and said the public does not have the right to access non-navigable waterways. So even that law is not being applied universally throughout the United States. So what about Georgia? We are different here. Unlike those Mountain West states, we have the regulated riparian system of water rights, right? So the right to use water generally attaches to land. We do not have any constitutional or statutory provisions establishing state or public ownership of the water itself. Even though landowners do not technically own the water in Georgia, we don't have that sort of enshrined public ownership of the water itself in our laws or our constitution. We also have a long history here in Georgia of recognizing exclusive private rights in non-navigable waterways. This was true under early common law, and it's true under our existing law. So Code Section 44-8-3 recognizes that the owner of a non-navigable stream is entitled to the same exclusive possession of the stream as he has of any other part of his land. What that means, at least to me, in my opinion, is that it would be much harder in Georgia to justify expanding public use of waters for fishing in non-navigable streams. We would certainly have concerns with constitutional takings claims, for example, especially where landowners have had a reasonable expectation of a property interest and have put money into that property and into the uses of that land. So navigable waters are different, though. We've seen historical public use of navigable waterways. There are public trust concepts under United States Supreme Court decisions. So that's really the distinction there. So I thought that would be helpful for the committee to have that information moving forward, especially being up here where I know people have concerns about private property rights. And I'm happy to answer any questions if the committee has any. Thank you.
Thank you, April. Any questions from the committee? No questions. Appreciate it.
Thank you.
All right. I'm going to ask a friend of ours, former Senator, State Senator Judson Hill, to the podium.
Chairman Webb,
Gentlemen, distinguished members of the House of Representatives, thanks, former colleagues. Enjoyed many, many years serving alongside y'all. Appreciate everything you do professionally and personally to serve the people of our state. Thank you for this community, for everybody coming together and for hosting, and also for Old Toccoa Farm. Y'all do a terrific job. Representative Johnny Chastain is one of the best, and we're excited that he's here. I actually live in this area two-thirds of the time these days after, in the wisdom of the people of the state of Georgia, I lost a congressional race and left the Georgia Senate. More fly fishing for us, right? And also I can't go forward without also giving great honor, respect, and gratitude to the men and women who serve with the Department of Natural Resources for our state, and your dedication and service without the necessary compensation, in my view, or resources many times. And thank you very much for each one of y'all for what you do and what your families allow you to do on our behalf, sincerely. I'd like to say a few things. I want to keep it brief. But I'd like to say first that private property owners, in my view, are the best steward and always have been the best steward of their land, not the government, federal nor state. And this is not the time to begin changing that at all. My focus today is going to be narrow. It's going to be on the Constitution. I've looked at some of the hearing video along the way. I've been in your chairs. I understand that you're hearing from a lot of different perspectives. I like to just narrow on one small niche, from the legal perspective, maybe as an attorney, hoping to be helpful. I heard the last speaker, thank you, mentioning the Constitution there as well. If the public trust doctrine is changed to include navigable waters in the definition, it would infringe on the Fifth Amendment of the United States Constitution and also the Georgia Constitution taking clauses, which require just and fair compensation to the property owner. It's a condemnation scenario that you're maybe familiar with or heard of with land. They have done that in the state of Georgia with like expanding the roadways and such. This is not the place to do it. And we actually heard that other states that have the public trust doctrine related to the fishing rights have actually done that, as the lady just stated, in their constitutions. They've done that in their constitutions, not in law. The hurdle for a constitutional change, as y'all know well, is substantial. 2/3 of the legislature and the majority of the citizens of the state of Georgia required. It's a huge high hurdle, is intended to be, federal and the state level. Today, we know Georgia law does not allow people to trespass on private property without permission. And the language of H.R. 15 is, as we know, it has the appearance of a slow attempt to allow that to happen. And that's what I'd like to briefly speak to. There's some concerning statements in there. And perhaps, if anything, the public trust doctrine should be changed. That statute at 5212 should be amended to state, I actually done this too many times. Actually, I came up with the proposed amendment for the public trust doctrine, but it simply would be, it's just a long sentence. I'm not going to read the sentence for the sake of time, but saying that the public trust doctrine should never be used to extend Georgia rights of any kind to private property owners by the state's rights to private property owners' lands on non-navigable waters, nor should any change in that definition of non-navigable waters affect the rights of private property on non-navigable waters. I can give this to y'all. That obviously needs some wordsmithing, but I'd go the opposite way and reinforce the statement in the public trust doctrine that we have in Georgia to go, it's going to reinforce the rights of private property owners, and you can't use this doctrine to change that definition of navigable waters. Couple of points. There are concerning lines in the resolution, line 33 to 36, related to the notwithstanding everything the DNR does to prevent that language there. The streams that flow through private properties are I'll just read it. The DNR does without stalking private property landowners or attempting to prevent the public from fishing on private streams that flow through their own private property. So the public's attempting to prevent them. They should, because it's their property, as we know, the stream bed issues and such. When the state grants a public right to someone else's private property, which includes the stream beds in law owned by private citizens, then under the law in the state of Georgia, the state has taken or otherwise condemned that property. The state has in effect taken the property of the private landowner. Simply a bill in the state of Georgia can't change and usurp the U.S. or the state constitution to do this taking without providing just compensation. Plus, it open up a plethora of litigation across the state. It potentially give private citizens who want to go on my land, your land, if we have a land on a stream, to sue the landowner for violation of their rights to fish on the private landowner's property. I mean, plus the liability issues and such. I'm not going to get into all of that, but I just want to touch on some issues that really can get out of hand and also would harm the intent of what the state, I think, would be thinking about doing, and definitely in violation of the Constitution, which is where I want to continue my focus. Lastly, line 41 to 44 of that resolution in short says, it is unclear whether the state actually owns the fish or wildlife on private property, and the DNR manages the fish on private properties. I don't think it's unclear. The law is clear today. It says you can't do that on non-navigable properties. They don't have the right on non-navigable properties. We heard, I think I heard that the representative from DNR said, well, the DNR's task is to something like this. Excuse me. The DNR's task is to determine navigable and non-navigable of something like that. Please, I'm not quoting them, so please don't hold me to that. That's not the DNR's task. That's not an agency task. That's not a task of the federal agencies or state agencies to interpret the law in that manner, in my view. It's done too often at the federal government. It's done. We don't need to start that or continue that at the state government. It's y'all's right to do that on behalf of the people of the state of Georgia, the 11 million or so, and the many thousands, tens of thousands that you represent. I don't think it's the right of an agency to make those interpretations, and also through the proposed rulemaking and regulation changes that happen day to day. We know all too well that agencies across our nation who are not elected individuals, so they're tremendous public servants, they are often will recreate, change the law in their opinion, but really change the regulations and rules to determine the purposes that they want outside the purview of the legislature. And most of the time in Georgia, outside of my experience, outside the legislature even weighing in, because it's done when we're out of session. DNR is looking at doing that right now with the definition of delayed harvest or catch and release on streams across the state versus harvesting, to shorten the amount of time for catch and release and expand the amount of time for delayed harvest. They postponed that proposed rulemaking that was issued late June, early July into the spring because of some advocacy one other thing, I've heard the discussion about clarification. We need a clarification law. In all due respect, we all know that clarifications in the law, gentlemen, is a change in the law. Clarifications in the reg is a change. Because I'm a wonk, I went and looked at the federal Congressional Research Office definitions last night and did some research. And once again, there's some statutory language too. I mean, some case law, but also statutory language, federal level. You don't clarify law without changing something, right? You put it in writing. If you put it in writing, you make a change. Whether it's in a law or whether it's in a regulation or rule, it's a change. And I would suggest and submit that a change requires a law. And I would suggest, to the lady's point and others, that a change actually in this context would be a change in the public trust doctrine, and that moreover would require a change in the Georgia Constitution to do so. High hurdle, because you're changing the taking clause, impacting the taking clause of the Georgia Constitution. I think that's the hurdle. I think it's wrong to look at it any other way from a legal standpoint, but that's just one person's opinion. And if you want to go about changing the Constitution, y'all know full well how to accomplish that. I don't think now's the time to do so. I'd be happy to be a part of, on the sidelines, a team that helps explore these issues, because it is important for people to know where they can hunt and fish and all that, but to allow someone to trespass on property to take, to hunt or fish and take what they kill is wrong. It's not allowed in Georgia, and I don't think now's the time to start doing that. Thank you once again for your commitment, for your time, and for all y'all driving so many hours. Some of y'all, I know, some of y'all have driven many, many hours. It was an honor to serve with y'all. It's a blessing. It's a privilege, and thank you. It's a privilege to have y'all represent us still. Take care.
Thank you, Senator Hill, and thank you for your past service to the state, and thank you for your remarks. Mr. Ballou, Rob Ballou, Toccoa landowner, had the opportunity to be on Mr. Ballou's property last night, and certainly appreciate the host.
Thank you very much for having me here. My name's Rob Ballou. I do own, me and my family, a couple miles of private trout stream, and in Gilmer County, where we operate a private fly fishing venue, it's been a real blessing for us to have that opportunity, because when my grandparents died in 2007, without being able to transition to something that was able to help cover the cost of maintaining a large family farm that had been in the family since 1883, I certainly wouldn't be here today. It'd probably be a beautiful golf course like we see out here. Fascinatingly enough, as I've explored this issue, everybody thinks navigability is subjective, right? It's, well, that looks navigable, so it must be navigable. And certainly your stream doesn't look navigable, so it's not navigable. But the truth is, what does the law say? And just because we don't like the law and what it says doesn't change the fact of what it says. And here's what Code 4485 states. Navigable, Georgia law defines a navigable stream as a stream capable of transporting boats loaded with freight and the regular course of trade either for a whole or part of the year. The mere rafting of timber or the transporting of wood in small boats shall not make a stream navigable. Now that's pretty subjective. I mean, that's not very subjective. That's a pretty high bar. And the truth is, the reason they added the second part of that statement by saying the mere rafting of timber or the transporting of wood in small boats shall not make a stream navigable is because they wanted to make it even more clear. And people like to say, well, you have to take into context what they meant at the time that they made the definition in 1863. Okay, well, let's talk about that. A lot of people say today the Toccoa on the headwaters is definitely not navigable. Okay, it's the headwaters, it's wide, it's not very, very deep, but certainly below the dam is navigable. Well, guess what? If you're going to apply the 1863 definition, guess what wasn't on the Toccoa in 1863? The dam. The dam wasn't built to 1930. So you know what the river looked like below the dam in 1863 when this law was made? Just like the upper section. So you have to be very careful with what you apply to the standard, because just based on that standard, the Toccoa below the dam is not navigable. And the truth is, there's no difference between my stream or Fighting Town Creek and the Toccoa River, quite honestly. It looks different. But by Georgia law, it seems pretty clear to me that if you take the 1863 standard, it's not navigable. Now, would it be navigable today? Some people say, well, we need to use today's standard, right? I mean, well, what's today's standard? Is today's standard a barge? Is navigability for commerce even something that's regularly done? I'm sure it is probably on the Savannah River and places like that, but we have to be really careful when we start defining things in subjective measures that really aren't that subjective. Now, we don't like the definition in certain cases because it doesn't accomplish our end means, but that doesn't make it that it's subjective. Quite honestly, and Ms. Lipscomb has stated this for 3 meetings. She's been pretty clear that 200 plus years of case law has sided with the property owner, or even further back, right? So I think we have to be very careful on how we judge things with our eyes. And to Judson's point, when we start messing with laws to add subjective measures, you kind of let a camel's nose under the tent at that point, right? Well, it's 30 feet wide. Mr. Robinson has said in a couple times, maybe 20 feet, then it goes to 15. Well, maybe it's 200 to 400 CFS, certainly above 400. Well, the truth is that Toccoa would be 400 plus CFS today, because why is that? Because it's the dam. The dam was built. That dam wasn't there in 1863. Based on that subjective measurement of average median CFS, based on the way the stream was in 1863, it certainly wouldn't be navigable. So when we think about these things, and well, 1863, boats weren't like they were then. Just let me remind you, did people settle this country in canoes? The American Revolution, did they shoot cannonballs out of canoes? No, there were barges then, there were boats then. There weren't canoes. There's been major vessels used to transport goods way before 1863. So we try to conflate these definitions, and we try to make them subjective, and we try to make there be a lot of confusion. I don't think the law's that unclear. I don't think there's a whole lot to clarify here. We know what rivers pretty much are navigable in the state of Georgia. Those have been identified. And I think we have to be careful that we don't give any bureaucrat or bureaucratic agency the ability to define for our future what's navigable, non-navigable. And that's a real risk now, because SB 115 codified the public trust doctrine into law. That means the only thing they have to do now is change the definition of navigable, and they can take whatever they want to take of your private property. But here's one thing that I want to quote. Justice Holmes in Pennsylvania Coal versus Mahan said this: "We are in danger of forgetting that a strong public desire to improve the public condition is not enough to warrant achieving the desire by a shorter cut than the constitutional way of paying for the charge." What he was saying here is we don't take shortcuts, folks. We don't erroneously use an egregious definition of the public trust doctrine to accomplish a redistribution of wealth in people's private property to the state of Georgia without compensating them. That's not right. That's un-American. That's not what we do. And so we're halfway there now that SB 115's passed. The only thing that remains is just to change the definition, and let's change it as liberal as we possibly can. Because we don't have to do eminent domain. We don't have to do condemnation. We can just take it. And it's a slippery slope when you start messing with things. And I think I would ask this committee that I would hope you would take the same approach that has been taken over the past 200 years. The law has clearly fallen on the side of the landowner in the state of Georgia. And I think you guys would be remiss if you don't side with property owners, because that's the way the law's fallen. And so I would ask this committee that you consider doing nothing for the time being. I don't think there's any way you can come up with a solution to this by December 3rd. I think there's way too much work that needs to be done here. This is not the first time this has came up. This has been an ongoing discussion for hundreds of years now. And I think if we rush to something, we can do more harm than good. And sometimes it's better to do nothing. There are some conflicts and the law in certain areas of the state, but a lot of places it's working just fine. A lot of people have said if it's not broke, don't fix it. And I think we can get in a lot of trouble if we start messing with things. We can make it a whole lot worse than it is today if we start redefining things, amending things, especially when it comes to property rights. Thank you.
Thank you, Mr. Ballou. Mr. Jay Hamilton.
Members of the committee, thank you very much for the opportunity to speak today. I do greatly appreciate all of you attending, and welcome to my backyard. In many ways, North Georgia. It's been nice to hear already. I did put some notes together, but Chairman, you already hit on something very important to me. We are in a unique location, which the rivers of Georgia, the lakes and streams of Georgia, they do all vary based on the region. And I do appreciate the fact that you've acknowledged that, and the committee understands that in any of the recommendations they're going to be considering moving forward with this bill. And I will build slightly on Rob's comment there. I do think some more studies needed. With that being said, I do want to highlight just a few things personally. I usually don't put things in any particular order, but one, today I'm a fly fisherman. Two, I am a Toccoa River property owner. My wife and I's primary residence is fortunately right on the Toccoa. And lastly, I am a real estate attorney. So I do feel like I have a little bit of guidance here today. Some of the things that Senator Hill kind of hit on. I'm not going to get into the constitutional stuff. I'm not a constitutional lawyer, but I do think he brought up some important points for consideration in regards to the Georgia Constitution and what slippery slope may be entailed depending on where this study goes. In short, you have hit on a few of the things I was going to identify. We are looking at major discrepancies, for instance, the Flit, the Chattahoochee, the southern rivers there, and the Toccoa. It is a true outlier, folks. The definition of navigability, again, as Mr. Ballou pointed on, in a personal level, and I think for a public good level for this community, the Toccoa is something to really protect. I do think it provides a major important factor of the tourism and the benefits that drive some taxable opportunity and income to this community, employment and jobs for our community. But at the end of the day, there's got to be some kind of defining line. I don't think the private property ownership is really in question there. And again, that's my personal opinion, but there is no problem with, the public use of the Toccoa. I think that's the right thing to do. It's a great activity for many. People watching is exciting. You'd be amazed what you see on that river on a weekend basis. But I do think the navigability issue, I know is kind of an outlying conversation here. Is specifically to the Toccoa, and I do realize that again, personal unique aspect of North Georgia. Being able to define that's going to be important at the end of the day with this study and with this bill in some fashion. I know you are restricted a little bit as how far the scope of this bill can go, and there are relatively or arguably clear definitions of what is navigable in Georgia and what is not. But again, I harp on the Toccoa. 1800s, 100%. There was no question it was non-navigable. The other, what has not been brought up today, we have several additional regulatory authorities that regulate that river, most notably the TVA. Again, with the dam, they have a clear-cut right, authority, easement, access to use. They control the CFS that runs out of that river wholeheartedly. But I can tell you one thing. Number one, you're not going to get a barge. You're not going to get any type of transport or trade that you would see in a port city or everything, which again, I think is a great outlier here. You can separate port to private/public use. especially when that river's down. You will see in certain sections, and I hope you do get the opportunity to come out and see the Toccoa. I know some of you may have had the chance to come out to meet with our representative several weeks ago, and a beautiful location on the Toccoa. I'm a little biased as my brother-in-law built it, so it is, on that end. But with that being said, it kind of gives you an idea. Yes, when these waters are up, can you arguably navigate an outboard motor up and down that river? Yes. But when it's down, absolutely not. Drift boats, skiffs, anything to that nature, but absolutely anything with an oar for sure. But I do think the other facet, and two of the last things I would really like to go on, again, is one, you've got to be cautious, especially unique to the Toccoa, and I'm going to continue to harp on this, outboard use of motors. The DNR in rightful way has no real ability to articulate, is an outboard motor acceptable on a river such as that? There's nothing on the books against it, so there's no way for them to enforce that. And I think that goes back to a slight ambiguity of how you can define navigability again, folks. If any ambiguous language is going to prevent the regulatory authorities, and I think specifically to this point, DNR's ability to regulate these things. We have natural Native American fish traps, one of which is literally a stone's throw from here, right on the river, which is actually falls right above an arguable put-in public access, which is fine, that it would allow an outboard. And I've seen it, they'll float up, they'll ride the water when it's up, but as it's coming back down, they'll float back. And again, there's no law on the books to prevent that. I mean, there's nothing I can say, hey, you're in the wrong here. But I'd be curious about the situation if they misjudge, which is a very easy thing to do. That water goes up once or twice a day. It varies. It's not as though it's up for a month at a time or weeks at a time or even days at a time. It goes from I think on average they're sluicing, so I think it's about 550, which again, I don't agree with the parameters of 400 or below on a personal level, but those boats could easily just get stuck and ported. I mean, what are you going to do there? That's going to require another aspect of the DNR having to come out and, I don't know, I won't go so far as search and rescue, let's be honest. But I mean, it does create a slight problem, and it does impact the fishing habitats as well. These fish, yes, they do move up and down, especially with the situation of the waters rising and lowering. But they tend to have, fish kind of come back to some of their main habitats. You can see that on the private creeks and streams. You can't control exactly where your private trout are going to go at the end of the day, but routinely they'll find a good hole and they're going to stay there a majority of the time. I mean, you're going to see some transition, and running propellers. And again, I know this is a slight segue, that can really impact the natural wildlife protection of what we have unique to the Toccoa. With that being said, I do believe that wraps up a majority, if not all of my remarks. And thank you for hearing that, because I do think it's some of which we've touched on. I would completely argue that Toccoa is non-navigable. But again, further study, I think, can help determine that. And I'm okay either way. I'm not trying to prevent people. And I know many owners on the river, they're not trying to prevent people from recreational activities, but it provides a real gray area in navigable public access versus private. Creeks and streams separate and apart. Those are private. I don't think there's any question. But I do think it'll be important to narrowly tailor the language and the recommendations this committee can provide towards this bill to really clarify this issue. And I'm sorry that it is specific to our area, but it's very important to us. I can tell you that.
Thank you very much. The specific nature of your testimony is why we're here.
Thank you.
So I appreciate that. Representative Williams, I believe, has a question for you, Mr. Hamilton. Mr. Hamilton, I think you had a question.
Yes, sir.
Trying to keep it within. I think I understood you correctly.
Yes, sir.
Are you suggesting that this committee do nothing? Let me make sure I understood what you're saying.
No, fair question, sir. No, I'm not suggesting that. I'm suggesting further study would be necessary, and I think that would be the recommendation you could take back to the Gold Dome, is the context of there's a little bit more to articulate here than pushing this bill through right now, because I do think the underlying impact in the short term, with all good intent and purpose, there's some aspects that maybe have not come up to light in consideration, and I wouldn't expect them to unless you live in it, or it's an activity that, you know, it's unique to me. I'd actually love to see the difference in the South water, you know, the black waters. I've never fished them. I think I know it'd be a completely different experience than what I experience up here. So again, circling back to your point, sir, I do believe the committee should do something, report back that you're probably not, in my opinion, not quite ready to finalize this bill. I think you're well on your way, but I do think there's some additional items that really need to be articulated and addressed before this proposed bill is pushed through any further at that point.
I just wanted
Yes, sir.
clarifications after 1,500 miles of driving
No.
in 3 weeks.
No.
And here in the trout capital of the world, and never once having tasted a piece of trout. I just want to clarify.
That's fair. And I'll speak last. I know I need to go, but sir, thank you for that. Your travel has not been in vain by any sense of the term. Yes, I catch and release, but it's every Georgia sportsman's right to keep. Rainbow and personally, I'm not a fan, but it's very good to most. I would not recommend eating any of the Brooks or Browns, that's for sure. So
Thank you, Mr. Hamilton. Next, we have Rodney Tumlin with Trout Unlimited.
Find my eyeballs here for a minute. I'd like to point out before I get started that my grandmother was born and raised not far from here. In fact, her family was here from the 1820s before the removal of the Cherokee. And I was fortunate, while I wasn't raised here, I was fortunate that my parents had a small farm, and I was blessed to be able to fish the streams of North Georgia, Rock Creek, Coopers Creek, Noontootle Creek, and Tiggenetley Creek mainly. But gentlemen, good morning. My name is Rodney Tumlin, and I'm the chairman of the Georgia Council of Trout Unlimited. Thus far, I have attended the first 3 meetings that you have held, and thank you for allowing me to speak today. I'll be brief. We have over 4,000 dues-paying members in the state of Georgia and over 300,000 members nationwide. We are a cold water conservation organization that was formed 64 years ago to ensure the health of trout, their habitat, and the sport of angling. Here in Georgia, our mission is to bring together diverse interests to care for and recover rivers and streams so that our children can experience the joy of wild native trout and salmon. Here in Georgia, we have a long and successful working relationship with the Forest Service, Fish and Wildlife, Park Service, and Georgia's Department of Natural Resources. Each year, we work on stream restoration projects, youth education programs such as Trout in the Classroom. We support college and high school fly fishing clubs. We conduct clinics for veterans, first responders, cancer survivors, scouts, seniors, handicapped anglers, and the list goes on. I tell you this not to brag, but rather to show you the commitment we have toward our mission. You also have a mission today, or not today, but in the future, a difficult mission. And we understand and appreciate the monumental task that you have before you. Your decision will have an impact on fishing in Georgia for generations to come. From what I've gathered in my research on this topic, the question of property rights and fishing access will be determined by how this committee defines navigability. On the larger rivers and streams in the Piedmont and coastal plain, the question of navigability seems somewhat straightforward. However, and the trout water of North Georgia, our smaller, faster, colder rivers and streams, pose a different set of considerations. We have a trophy trout fishing industry that has developed on many of our smaller rivers and creeks, which by common sense are non-navigable. This multi-million-dollar industry is dependent on the ability of property owners to restrict access to waters that flow through their property where they own both sides of the stream bank. I urge you to consider this as you determine navigability. Here in North Georgia, we are blessed with tens of thousands of acres of public land that offer access to nearly 200,000 licensed trout fishermen. State and federal hatcheries keep our rivers and streams of these lands stocked with over 1 million trout a year. As you move forward in the decision-making process, I pray that you consider the uniqueness of our part of southern Appalachia. I pray that you can come to a reasonable and defendable definition of navigability that protects both property rights of landowners and the public access of our rivers and streams to anglers. You have a monumental task before you that will have a generational impact. Thank you for your time and hard work on this difficult task.
Thank you, Mr. Tumlin. Mr. Jeff Roach.
Good morning. My name is Jeff Roach. My family has owned a second home on the Toccoa for nearly 30 years. So obviously a vested interest. Let me apologize right off the bat. I'm going to read my remarks. I'm a retired banker, and one thing we never did, well, he sort of put me to shame here today, is give speeches. So you did a good job. So nobody wants to hear a boring, stoic-faced banker anyway. So I've watched with much interest the complete video of the two previous study committee hearings that were held in Gay and Clarksville, and was obviously clear from the public comments and even some comments made by a few of you gentlemen that the protection of private property rights should continue to be protected. It was evident that the public comments were overwhelmingly in favor of not redefining the definition of navigability or change any classification designation that would make many of Georgia's smaller streams now to be considered navigable. Public comments also appear to oppose the implementation of the public trust doctrine along these waterways that would amount to the taking of private property without justification or compensation. My comments on these matters echo the majority of what the speakers have said in the previous hearing, so I'm not going to bore you by only repeating these over and over. My comments instead are going to focus on something a little bit different that we haven't heard a lot about in these meetings, and that's unintended consequences should any changes to the current situation be allowed to take place. Mr. Worley sort of messed me up this morning. In his previous two meetings, he's opened up with a lyric from an old Marshall Tucker song, and he threw my notes off today by not doing that. So, yeah, I know. Yeah. But anyway, I'm going to open up not with song lyrics, but maybe an old story that you've heard before. A young outdoorsman from Massachusetts comes to Georgia to take advantage of our wonderful outdoor sporting activities. While duck hunting one day, he shoots a duck that falls on the other side of a fence onto property owned by an elderly farmer. As the young hunter starts to climb over the fence to retrieve the duck, the old farmer asks, "Why are you coming onto my property?" The young hunter responds that he's just retrieving his duck that he shot. The farmer tells the young hunter that duck is on his property and therefore it is his duck. After a few moments of back and forth as to whose duck it is, the old farmer tells the young hunter from Massachusetts, "The way disagreements are settled here in this part of the state is by a good old-fashioned slugfest." And that's where each party takes time slugging the other one until one party just can't take it anymore. Sizing up the old frail farmer, the young hunter agrees to this. The farmer insists on going first since it's his property, but the young hunter is really not that worried, doubting the farmer has the strength to deliver really much of a blow. The old farmer clenches his fist, rears back, and levels such a blow that it knocks the young hunter 3 feet off the ground and 5 feet back. Lying on the ground for a minute or two, the young hunter shakes off the cobwebs and climbs to its feet, fairly confident he can take this old frail farmer with just one blow. The young hunter says, "All right, old timer, it's my time." To which the farmer quickly responds, "I don't want that old duck. You can have it." Most of the testimony in the previous hearings regarding implementing the public trust doctrine or the reclassification of streams navigability designation has primarily been about fishing rights, and stream usage, and that's pretty much what we've heard here today. But something that has not been very much discussed is the right of hunters. Part of the definition of the public trust doctrine states rights that go along with the doctrine include, and I quote, use for fishing, hunting, passage, navigation, commerce, and transportation, end quote, and that both fish and wildlife are held in trust for public use. Since wildlife is mentioned in this definition, you must take into consideration the rights of hunters and their access to additional hunting sites that would become available if these suggested changes are implemented. Currently, a reclassification of any type of non-navigable waterway opens up not only fishing access to what is now private property, but would also open up hunting rights on that very same private property. Imagine, if you will, you're playing golf right out here in this beautiful golf course, and suddenly you begin being peppered by shotgun shell pellets from the shotgun of a duck hunter floating down the river just below here. Or vacationers and homeowners up the river here with young children staying in the many homes and cabins located on this river, or any other classified river for that matter, having to suddenly start dodging bullets from the rifle of a floating or even a wading deer hunter. This is a very real possibility. Remember, wading would be considered legal in a navigable stream at that point. Some of you gentlemen enjoyed some fine food yesterday in one of the loveliest settings in all of North Georgia along Mountain Town Creek. And imagine being that property owner, and you bought that property and paid a premium price for it because of the exclusive use of what has generations been held as private property. But now all of a sudden you're afraid to sit on that beautiful back deck overlooking the creek because hunters have legally entered the stream on that public road right there at the house, and now are wading up the creek with guns in hand less than 100 yards from that back deck. Now, I completely understand, I know hunting enough, that wading up a stream does not provide the most productive way to hunt, but opening up stream access could allow hunters to perhaps seek appropriate cover to maintain a stealthy profile that is provided by the low-hanging tree canopies while remaining in a boat or kayak or anything on the water, right out the back door there. I understand the odds of shooting whatever it is you are hunting and have it fall in the water is rather small, but Mr. Worley has stated in previous meetings and here today that nothing proposed is intended to allow access to private property outside of any reclassified water. That's good to hear, but there's more to that position than may be out of his organization's control. It's not out of the realm of possibility for hunters to argue that under the public trust doctrine, they have an access right to enter private lands in order to exercise the public right to use the trust resource of wildlife. Again, wildlife is in that definition of the public trust doctrine. Now, courts have historically held in favor of private property rights in this argument, but in the wake of expanding the public trust doctrine, we're becoming to see decisions that are contrary to where private property rights are slowly eroding, especially in other states. I did some research and saw two cases fairly quickly, one in New Jersey and one in Montana, where the court allowed access across private property under the public trust doctrine to access resources made available per the public trust doctrine. They allowed them to cross private property. I mean, how long will it be here in Georgia before our young duck hunter from Massachusetts will have the right to enter that old farmer's private property and to retrieve that duck under the public trust doctrine? Do we really want to go there? Reclassifying non-navigable waters or implementing the public trust doctrine for something that, in my opinion, it was not originally intended to be used for will put us on that track. Currently, hunting would be considered illegal along the crowded waterways without permission, of course, from the property owner, but a reclassification of them would change that. And when I say crowded waterways, I'm referring to the many homeowners of private homes along the banks, not just people using the water itself. While the story I told earlier was meant to be humorous, I'm afraid opening up hunting rights under the public trust doctrine or by the reclassification of stream navigability along some of our crowded riverbanks will result in confrontations that may not end as well as my story ended. Armed individuals confronting other armed individuals usually does not end well. And I can assure this committee confrontations will happen. I keep going back to a statement Rob made. I've heard it in a previous meeting, maybe even the two previous meetings. If it's not broke, don't fix it. To echo a speaker from the Clarksville meeting, I would ask this committee not to make a recommendation to take away private property rights by any means, but instead consider making further recommendations to protect them. Either way, let's not put into effect anything that would put anyone's safety at risk through any unintended consequences. And last night we had a discussion that haven't thought about unintended consequences. And these changes are implemented, the state, we're in for a lot of lawsuits. A lot of lawsuits will take place if these changes are implemented. Thank you. Thank you for the work that you're doing. We appreciate it and appreciate you coming up here today and for your time. Thank you.
Thank you, Mr. Roach. All right, I've got a couple text messages on here saying we need to take a recess. The coffee is getting to the group. So I'm gonna say we take a 5 minute. Let's take a short recess till 10:10. All right, till 10:10. All right. Let's come back to order. Jeff Roach, Charles Glenn. So we stopped at Jeff Roach. This guy said that he's got to be somewhere. I'm going to ask that he come up next. I'm going to ask that Terry Bramlett make his way to the podium. Terry Bramlett. Hey, how are you? Good. That's fine. Mr. Terry Bramlett. Okay. Okay.
That's pretty good stuff. It's almost as good as South Jordan Prince.
All right, Mr. Bramlett, I'm going to go ahead and open it up for your testimony. I understand you have a van load of trout needing delivered to Atlanta, so I want to make sure that fish makes it to its destination. So
Thank you kindly, Mr. Chairman, and thank you, committee members, for the opportunity to speak to you today. My name is Terry Bramlett. I own Bramlett Trout Farms. It's a trout hatchery and production facility. We've been in business now for 44 years. You can find our trout on many of the menus in Atlanta, as well as Washington, D.C. They won the James Beard Foundation Award in New York City, been on the menu at trout at facilities around the country, including French Laundry in Napa Valley, Charlie Trotters in Chicago, and many consider them to be the finest trout around. A good part of our business is also stocking these private streams that we've heard a lot about today. We had mentioned by the mayor of President Carter and First Lady Rosalynn enjoying trout fishing. I assure you that those trophy trout that they were catching over on the Soquet River were stocked by me 3 days prior to their arrival. In fact, I could tell you their names. The fishing industry in our part of the state has become a significant economic factor. I also chair the Board of Education here, and the SPLOST revenue that we receive from visitors to this part of the community has allowed us to roll a millage rate back for 8 years in a row. We have zero debt, and our children have everything. It's a huge part of our economy, and a lot of that is attributed to these private stream owners that have me stock their streams with literally the trout of a lifetime. You can come here and catch a trout. We put one in the Soquet River that weighed 26 pounds. It's truly the fish of a lifetime, and it's the experience of a lifetime. But these private property owners maintain their streams. They feed their fish. They guard them. They care for them. And those private property rights, we simply can't afford to infringe on. Now, I would argue that the definition of navigability probably doesn't need to change. I think the traditional definition is significant and is appropriate. But I also chair the Aquaculture Commodities Committee for Georgia Farm Bureau, and I represent aquaculture from here in the mountains to the coast of Georgia. And those folks that have private aquaculture operations, even on that larger water, need protection. I enjoy both hunting and fishing, but I would also argue that those hunting and fishing rights do not supersede private property rights. They simply do not. As illustrated by several of our speakers already, to use the wet boot doctrine to wade up a stream and fish in my trout raceways could be devastating. This bill, as you know, was passed at the last minute. It didn't go in committee, and I believe had it gone to committee, it might not have even made it to the floor because there are so many unintended consequences. Probably with the exception of my colleagues with the Department of Natural Resources, no one in this room may realize that the virus that causes infectious pancreatic necrosis in trout can survive 3 days on a dry surface. On your wet boots, it can survive indefinitely. Reference was made to Colorado and their turn toward a more conservative approach or to private streams. I can tell you why. Because wet boots spread the protozoan that causes a condition known as whirling disease, which is devastating to trout, and it decimated the trout fishing and trout stocking programs in Colorado for years. Hatcheries were dry. They could not produce anything because of this protozoan that was carried unintentionally by a wet boot. And there are numerous pathogens that can be spread the same way. Gill lice can be easily transported on a wet boot. It poses a threat to those of us who operate commercial operations. We've been in business, as I mentioned, for 44 years, and I turn down calls daily for people that want to come to our facility to fish, and they're perfectly willing to pay for those fish, but that revenue is certainly not worth the risk of introducing some pathogen into our hatchery and production facility. So that's a very real possibility. And again, an unintended consequence of expanding this ability to walk in the water and fish. Again, I enjoy fishing and hunting. I can do it on my property. I can hunt and fish on public property. I can hunt and fish on my neighbor's property if he gives me permission. But as illustrated before, it's simply wrong to allow people to impose on those private property rights. And I think that's one area where you're going to have to address in this bill. There needs to be consideration for private property owners. And our situation here in the mountains is quite different. I can argue and had legislators assure me that we have no navigable water in this part of the state. And I would agree with that statement. I've paddled the Toccoa River many times. There's no way you're going to get a barge down it at highest water level. It's just not going to happen. The folks down in South Georgia, however, deserve some protection as well. And again, I represent aquaculture throughout the state of Georgia through Georgia Farm Bureau. We have to address the issues that will protect their businesses and their hard-earned livelihoods without imposing on the public's right to hunt and fish. To allow someone to go into those places and fish would be the same thing as me taking my 2 little bird dogs down to one of the quail plantations in South Georgia, hopping the fence and harvesting quail that the owners had purchased, cared for, maintained. We can't stomp on the private property rights, and that's basically what I wanted to convey to you. But I would appreciate any consideration you can give to private property ownership and the consequences of allowing the public to intrude. I have had to turn people away that wanted to argue that the fish that I purchased the eggs, raised, spent 24 hours a day for a full year to get to market size, fed with feed that cost me $50 to $100 per bag that I buy by the ton, belong to them. They do not. They belong to me. And I'm not going to stand there and watch somebody throw their beer cans down in one hand and fill their cooler with my possession. It's just not going to happen. So if you can find a way to give us some consideration for private property ownership and the aquaculture industry, because it is a big part of aquaculture in Georgia. And we appreciate your time and the opportunity to speak. And thank you, Mr. Chairman.
Thank you, Mr. Bramlett. Our next speaker is Charles Glenn. Mr. Glenn? Mr. Charles Glenn? All right. Mr. Bill Oyster. As he's making his way up here, I'd like to thank Mr. Bill for his hospitality with the committee, and also thank you for the art that you've put together in your shop. It's pretty fabulous.
Absolutely. I appreciate it. All right, let's see. I don't usually make notes for this sort of thing, but I've got so much to say on the subject. I wanted to make sure in a limited amount of time I was able to cover what I wanted to say. There's been a lot of intelligent talk regarding the laws, their history, the potential and their meanings. But you all are elected lawmakers and law shakers. So I'm going to leave that to you all, and and I'm going to speak to some of the practicalities of the subjects that we're discussing today. Okay, so by way of introduction, my name is Bill Oyster, and fly fishing in general, not fly fishing till later, but fishing in general has always been at the core of my life, both personally and as a career. So I'm going to talk about myself for just a moment, not because I'm selling myself, but I want you to understand where I'm coming from and how deeply intertwined I am in this subject. And I have a lot of experience on it. Now, the end result of this one way or another will not affect me one way or another, as far as I'm not going to sell one more fly rod if the Toccoa is opened or closed. But I do have some strong feelings on the subject based on my own experiences. So, I'm the owner of Oyster Fine Bamboo Fly Rods, and we make some really high-end fly fishing rods, and we've built slowly over 25 years, and it's been very successful for us. We moved to Blue Ridge, Georgia, intentionally 15 years ago. The business has been operating for 25 years, so we already had good success when we came here, and we could have moved anywhere we want, and we came to Blue Ridge specifically for the fishing opportunities for ourselves and also for our customers. We were the 2019 Small Business of the Year, voted by the Georgia Department of Economic Development. And we've received commissions from President Carter. So those pet fish that he was catching that were stocked 3 days before, I was the guy at his shoulder telling him where to cast. So thank you, Terry. I grew up as a child in Northwest Wyoming, and I got to see the Rocky Mountain trout fisheries and how that works out there. And I grew up as a teenager in South Georgia, in Homerville, Georgia. So if we wanted to go see a movie or take a girl out to a date, we had to drive to Waycross to make that happen, because there wasn't and still isn't a whole lot down in Homerville. But that's where I graduated high school and then moved up here to the University of Georgia, and that's where I met my wife, and it's also where I discovered fly fishing. And I had no idea that there were trout in Georgia, being from Wyoming and then South Georgia. I thought I had left all that behind. And some friends said, "You want to go camping and fishing?" And I said, "Absolutely." And I was shocked to see what was actually available up here, and I've been smitten with it ever since. So as an angler, I would love to have access to all of the fishing opportunities our state offers. In fact, when my friend Jeff Roach back here heard that I was asked to speak here, he said, "Well, what side is he on? Because, you know, I'd like to go in and fish every inch of water in here." But I also have some experience that I know that it's not that simple. So in addition to my fly rod business, I have in the previous owned fly shops. I've been a professional fly fishing guide. I've managed teams of fly fishing guides that have worked public water and private water. And those two things are a very unique distinction for this area up here, and both have their value, and they both have a lot of value, especially when tourists and tourism is our number one industry up in this area. So let's see. For me, the question is a very simple one, and that is, I'm all in favor that our non-navigable waterways must remain secure in their current private landowner controlled access. All right. And honestly, I doubt that it's going to go that way. And I found it hard to believe that this was even in question when it came up. But I also realize there's some differences up here. Maybe not everybody is aware of them. So I'm just going to speak to some of those practicalities and why it's a good thing up here, a good thing for us to keep it that way. All right. So now, are there some waterways that needs to be clarified for? Absolutely. And I think that's obvious because I've heard a number of misinformed statements at this already, and these are the people who are really interested and care about the subject. One, for example, the Toccoa River, I believe, non-navigable waterway. Am I correct in that? Okay. Also, on the drive here, I watched commercial guide boats launching their boats at a public boat ramp to take out at another public boat ramp for the purposes of fishing, for the purposes of commerce. And I say that with our sheriff right back behind us, and I highly doubt he's going to be at the public boat ramp arresting them when they pull out. The people have already decided which waterways are public and which ones are private, and I think that's something that should be determined on the local level. Now, is it a law change? Is it a choice of enforcement? I don't know, but the Toccoa is a sticky wicket here. People use it for commerce every day, and perhaps maybe the definition of commerce needs to be updated somewhat. You know, there's not a lot of business going on any of these rivers floating bales of cotton on barges down the river. All right, so for us up here, commerce on a river means guides, tubers, kayakers, paddlers, sunbathers, tourism. That's our commerce in this area. And if you take away a river like the Toccoa from that, you know, it's a real problem. It's a financial problem for a lot of folks. But to open access to all non-navigable waterways just to get this one river clarified, I also believe it is not the right way to go. Okay, it's with the intention to give something to the people. I believe you'll end up taking more than you would ever give. All right. So the first thing I was asked to speak about was the degradation of the fish habitat due to the unavoidable increased impact of man on our trout streams if open access was allowed to these fisheries. Things like bank erosion and the resulting siltation, which harms aquatic insects, which are the primary food source for trout. Things like damage to underwater vegetation and the disturbance of redds, which are the beds where trout reproduce. People walking on them kill them and no more reproduction. Make no mistake, this damage over the months and years of opening access to these streams would surely occur. But I have no interest in this discussion because, simply put, we wouldn't have months or years to worry about this problem. Upon opening access to private streams like the Noontootla, Mountain Town, and the Sequoia, with their legendary fish and angling opportunities, those same opportunities will be no more. These fisheries, as we know them, will cease to exist in 3 weeks. That's how much time we've got. 3 weeks, mark my words. And how can I claim this? It's because I see this effect firsthand every year on Georgia's delayed harvest streams. From October to May, these streams are stocked, patrolled, and managed, enforcing special regulations of catch and release. These restrictions effectively reduce angler numbers to catch and release sporting enthusiasts only, much like on our private fisheries, and within 3 weeks of their season's end and their opening to the regulations and interest of the greater general fishing public, none of these places are worth fishing. They're virtually empty. I've done it myself. I've driven a long ways to streams in North Carolina, get there, fish for 2 hours without a bite. And what's going on? I look at my phone and realize the date. I'm late. It's over. It's gone. And that's the same effect that would happen to these. So you can't give people this legendary fishing that exists in these private streams up here. They would have it for a week or two, and then it'd be gone. All right. So one may wonder, and there was some talk, how a state like Montana can have open access laws and some of the best trout fishing in the world. Simply put, they have a much richer ecosystem where a fishery can maintain itself through natural reproduction, abundant natural food source, and a strong angler's catch and release ethic. Georgia trout streams, on the other hand, have a much more acidic pH, resulting in a much less forgiving habitat where food is more scarce and natural reproduction is in many of them non-existent. Georgia streams require heavy stockings of trout, which are often only expected to live until they find their way into a frying pan. And I have no problem with catch and keep fishing, and many of these streams are managed in just that way, these public streams. All right. But But to reach truly impressive size and numbers that made this area fishery famous, they require careful management, feeding, often on a daily basis, restrictions on access, and catch and release regulations. In short, you can't give away something to the public that only exists because it is private. Opening fishing access to our private waterways will effectively put an end to one of our area's most revered fishing opportunities, which currently exists because, and only because, these waterways remain private, as they should. And that's all I've got to say about that. Thank you very
Mr.
much.
Worcester. I think Mr. Al's got some questions.
Yes. Yes, sir.
I had to say I had a cap that had your name on it, and here I was thinking that it was oysters down where I'm from, and I've got to tell people I met the guy who oysters are named for.
That's right. That's right.
Thank you for your hospitality. I appreciate it.
You betcha. Thank you. Thank you all.
Thank you. Next, we have Steve Seitz. Steve Seitz.
Thank you, Chairman Burchett and the committee members for being here in service to the state and on this committee. I'm going to be brief. A lot of the folks have already touched on what I was wanting to talk about, and they've done a really good job with it. My name is Steve Seitz. I'm a property owner on the Upper Toccoa River in the Dial, Georgia area, and a recently retired game warden. So this topic is really important to me, and we've worked it over the years too. So my wife's family, who are the Van Zants, settled the property in 1832 in the Dial River Valley, and they continue, and we continue to conserve that as a farm. Been run from a farm ever since, and it should always be considered a farm. Our property lines are the center of the river, or both sides. And I always considered the Toccoa as being non-navigable, and hopefully it'll stay that way. Like I said, I'm not going to talk about other folks, what they've done already, but just give you a little example of what I've worked through over the years on the Toccoa. When I first started up here, it was my predecessors and all, it was enforced as a non-navigable stream, and it remained that way a long time. And then somewhere over the years, I guess as things started, people coming in, a lot more fishing access and things. And just like Mr. Robertson said, it kind of became a gray area for folks. So they started interpreting the law a little bit, and then changed some of the enforcement the ways it was enforced. But this was after I left. I ended up transferring to another region, and it didn't, I didn't know about it for a while. But then later on, a decision was made to change it back to where it's more non-navigable now. But you can see how much confusion that makes for all of us. And I appreciate the comments that you made earlier, that you're here to try to provide some clarity to that. And hopefully you will during this process. I mean, my opinion would be, is just like Mr. Ballou said, is keep the law the way it is. I think it's very clear, and that's a good example of what a navigable stream is and the definitions. So, one thing I listened to some of the other meetings, the two previous ones, and heard a few things that concern me. And it seems like it's happening again, the way things get flip-flopped, or how you're trying to determine navigability. And one thing was the CFS stuff. I didn't really know what the CFS was, so I kind of, I did some research on it, and I provided a little list of what I looked up there from the U.S. Geological Survey, and they kept records for all the streams in Georgia. So you can see the difference in the stream things there. The Toccoa River, they had 6 years of date of it, and this is the Upper Toccoa in Dial area, and it specifically said it was less than 400 CFS. And then some of the traditional streams that we, know and think of that are truly navigable, that can live up to the definition, their CFSs are measured in thousands of CFS. not hundreds. So, I mean, that's just something that we need to think about. And that holds true to all the streams. We talked about it. You know, Toccoa is different than the Cartacay versus the Sequoia. You know, that's just what through my years of experience, that they all have their different features and things like that consider. And I appreciate y'all doing that for us. And the other point I was going to talk about was the hunting, and we've already covered that too. So I mean, that's something else to keep in consideration, because if you consider a very narrow stream navigable, then it opens it up to hunting that folks can go on the private property, and that would cause. Can you just imagine how much conflict that would cause in the future? So, I mean, like I said, I'm not going to say a whole lot more, because a lot of it's already been covered. You've heard it last 3 meetings you've been to, and then today too. But I appreciate your time and listening to this.
Mr. Seats, I appreciate your testimony in particular because you're, one second, Mr. Chairman, because of your past service with DNR. I mean, I think that's a unique perspective on having to make the determination of navigability and non-navigability. So coming from someone that has done that on the banks, I hold your opinion in high regard. Chairman Gunner?
Thank you. And I might should have asked some of the others this question, and I hope you can answer it. What makes up the CFS? How is that formula determined?
You know, I don't know. That's the first I've heard of it, when I guess Mr. Robinson had it in his presentation. I'm sure there is, and somebody else I'm sure can speak on it better.
Because is it just the flow of the?
It's the flow,
water
the amount of
past
water
that?
flow, the cubic feet per second is the amount of water flowing through the stream.
But does it take into consideration the width of the stream or anything like that, or the depth of the water?
It does not. But I think that's something that you as a committee, I just wanted you to have that extra information there to look at it, to have for the different streams that are there, and it's available online to see what if you have questions on additional streams.
I was looking at your data with the Flint at 819 CFS.
That was at Thomasville, or Thomaston, and then you can see the difference in Albany.
What I looked at in Gay, Georgia, was no different than the streams I see up here. It's just it was a lot wider.
Right.
Yeah. Okay.
Thank you, Mr.
So
Seitz.
that's why I'm asking the question is, how do you determine the CFS? Okay.
Mr. Roberts, will you come up and maybe answer Chairman Gunner's question?
Does it take into consideration the width of the river?
Yes, sir. So CFS is cubic feet per second. It's entirely a water volume measurement and a rate of flow.
So, but the volume of the river is determined by the width of the river as well?
It's the width and the depth. Yes, sir.
All of that is part of the consideration for
Yes.
CFS? Okay,
Yes.
Thank you.
Yep. And the numbers that I'm talking about came from USGS, as Mr. Sykes mentioned, and they're a mean annual flow, so it's an average over a year's time.
Very good.
Thank you.
Let's see here. Terry Bramlett. Eric Wilhelm.
Thank you, gentlemen, for allowing us to speak on this. I'm going to disagree with that answer right there real quick. My name is Eric Wilhelm. That CFS is just strictly a volumetric measurement. It could be a foot wide. It could be 60 feet wide. It could be a foot deep. It could be 30 feet deep. It takes absolutely zero indication of depth. You could have a 40-foot wide creek with a 20-foot waterfall. I doubt if it's very navigable. You could have the same thing with 10-foot boulders in the middle of it. It's not navigable, right? So CFS and depth are great indicators of maybe size, but not navigability. And so when you start to try and pretend like there's different parameters to define navigability, now you're getting into the slippery slope that people have been talking about all morning. And so that's not the way the statute's written. That's not the way the federal nor the state laws are written and define navigability. They define them very succinctly. And you will not see CFS or depth or width commented on in those definitions for a reason, because it doesn't matter. So it's strictly the navigability of flow. So I won't repeat what everybody else said. Why am I here? I usually introduce myself as a forklift operator. Why? Because I've started some big national supply chain companies. I'm a serial entrepreneur. I've owned banks and dealerships, and just sold a big national supply chain company that has locations in 22 different states. And I own property on the Gulf of Mexico, a horse farm on Altoona Creek, and 2 miles from here, as a crow flies, on Fighting Town Creek, I own a great little, beautiful trout fishery. So I'm unfortunately an expert on riparian water rights, and been involved in quite a few things. So when I asked my real estate agent to find us property, I said, find me Colorado, in Georgia, where I can own both sides of the stream and those property rights and those water rights, so I can walk off my deck and privately trout fish as I were, right? And she said, you're going to pay a premium for that. I said, I understand that. She said, you're going to pay a big premium for that, both sides of a trophy trout stream like that, the coldest water in Georgia, in Cassis Valley. It's going to cost you some money. And now we're up against the wilderness, right? Up against the Cohutta almost. And so it's really prime property. And I said, I'm willing to do that. So private property includes that. Now, you can't pretend, in all those businesses I've started, our biggest rule is we don't pretend. You can't pretend like you have private property, which by definition includes the right of exclusion, and then take the right of exclusion away by blurring it with a doctrine, an English doctrine of, I'm going to be Marty McFly here and tell you a story. We're going to go back to the future. This is a true story. So help me help you, in the words of Jerry Maguire. It's 2 movies. This is a true story that just happened, and it just completed in the legal courts within the last month. And it's been a 5-year lawsuit. Most of you know, down in Florida, Walton County, the beaches of 30A, Santa Rosa Beach. So that's Dunelm, Blue Mountain, Seaside, Watercolor, Rosemary Beach, Alice Beach, Inlet Beach. The county commissioners and state legislatures promoted that property down there to the world, to the detriment of the county, because they didn't provide any more public beach 20 years ago than they have this year or last year. So what happened? They increased the tourist traffic by more than 10-fold and included no more public beach. There wasn't any place for those people to go, right? But when we buy property down there, you can buy property where your water, your property D line goes to the mean high tide line, which is you guys are talking about. Now, there's a correlation you're going to see here, right? Exactly what we're talking about in this room to what just happened, and you can see the future. I can tell you how the story is going to end. I've seen the movie. So if we buy the property that goes to the Gulf of Mexico in the mean high tide line, which is an ambiguous line in and of itself, which the sheriff will attest to, because it's his challenge to figure that out when we call him and say, hey, there's someone on my property, you're paying a premium for that. Now, in 2017, 2 charlatans in the local community decided they wanted to do a public good and return the beaches to the public for an old English doctrine called customary use. Customary use is an English common law doctrine that sets a precedent that if you can prove ancient, since time immemorial use, reasonable use, uninterrupted and undisputed use, then you can go ahead and claim customary use in a court of law to allow the public to use that property, which in this case was the White Sand Beach. So why is it like this? Because ambiguous terms started coming into the conversation. The TOA, the property is not taxed. It's unbillable. So how can it be taxed, or how can it be owned? Well, the public owns that. Well, where's the mean high tide line? So all the blurred lines that are appearing here today appear to the same argument that we had down at the beach. thousands and thousands of depositions were taken, and I do mean thousands. Tens of millions of dollars were spent. The unfortunate part of that story is the beach owners obviously have the highest priced properties in Walton County, so they were paying for both sides of that lawsuit, right? They were paying to sue themselves and then defend their private properties. And this is where you're headed. This is exactly where you guys are headed. And when you try to take private property rights away, the Fifth Amendment, and a taking, which is exactly what would happen, which is what happened there, then you're going to have a lot of people defending their private property rights. And and when that happens, you have a public that has an uprising, because now you've created a have and have-nots. So in order to defend that lawsuit, we had to make sure that it was disputed, because if it was undisputed, we lose. So we had to put up signs. If you go to Walton County now, you'll see private beach signs on every single private beach, and it is ugly, and it's disgusting, and it's terrible, because that was a beautiful, beautiful place. There's chains, security guards, and private beach signs on every single private beach because of that lawsuit. You don't want that in the North Georgia mountains. We've heard already the analogy of people have guns up here in the mountains when you go fishing and when you have a homeowner. So the reason I bring that up is because there were a lot of fights. There were an awful lot of people that thought they knew the law, and since there was a lawsuit engaged, they would come on private property, go on social media, camp out, have parties, and promote a common uprising on private property to establish customary use. You're going to create the same thing here on private trout waters, trophy trout waters. So I implore you to leave it alone. That's how it's going to end up. It's going to be ugly. You're going to have lots of lawsuits. You're going to have really upset people. You're going to you look out there. You're going to destroy that beautiful mountain and creek country, forcing us to put up chains, signs, and security guards. So that's it.
Thank you, Mr. Wilhelm. I apologize, but I've got to take another 5-minute recess. Give me 5 minutes. We'll come back at 10:55.
There's a grandson that has a Bill Oyster bamboo rod with his initials on it. Only because his initials are the same as mine, but he still has it.
Thomas, 1055. Mr. Turner, I told you you were up next, but I found that Charles Glenn is back, and I'm going to call Charles Glenn up first. He's back. Charles Glenn, come to the podium, please. Who said he was back? Rob. Right here. Charles Glenn? No, Mr. Turner, I was just told that Charles Glenn we called earlier was back, so I was going to recall Charles Glenn.
Maybe not.
And I guess Mr. Glenn is not here. Oh, okay, all right. Thank you, Mr. Glenn.
Sorry. Thank you for having me. I'll try to be as brief as I can here. My name's Charles Glenn. I'm a serial entrepreneur and property owner in Gilmer County. I own a tract of land on Hills Lake that's navigable to Mountain Town, and also own a large family farm in Oglethorpe County in East Athens. Been in my family for 7 generations. We still own that property. It was given to us by my great-great-great-grandfather as he fought in the Revolutionary War, and we've maintained a large tract of that to this day. I stand before you today dedicated to concern study with a palpable interest in the situation that's currently before the committee. I'm not going to bore you guys with an overview of the events that led to the proposal for the State Bill 115. The central facts are clear. The bill embedded in this public trust doctrine into Georgia law for navigable waterways to ensure all citizens have equal access to fish and hunt in these waters. The central component of this bill and the origin of this great debacle is within the definition of navigable waterways, according to OCGA 485, subsection referenced by the Governor Kemp in his signing statement of the issue Bill 115. The definition of navigable waterways is codified as being a stream which is capable of transporting boats loaded with freight in the regular course of trade, either for a whole or part of the year. Mere rafting or timber or transporting wood in some small boats does not make a river navigable. Nevertheless, due to this conflicts and confusion regarding public use of the privately owned non-navigable waterways, this study committee was formed under H.R. 519 with the explicit purpose of clarifying and resolving such issues within the understanding of the public fishing rights within private property. The stated purpose of this committee is still displayed in lines 41-52, H.R. 415, which states, although the state may convey ownership of the stream beds to private landowners by statute or land grants, such is the case for both my properties and many other private landowning citizens here today. The bill continues, and I'm not going to go into that. In layman's terms, H.R. 519 created a study committee with one definitive task, redefining the limited scope of the origin of definition of navigable waterways at the expense of solidified property rights. This is not simply my interpretation, but the express directive of this council was displayed in the statements at the first study committee hearing in Gay, Georgia. In this meeting, the head of the DNR fisheries for the state of Georgia publicly advocated for the expansion of the definition of navigability. I'm shocked and appalled at the avocation for this definitional expansion of a word which would allow further unjustified infringement of property and privacy rights. With the public trust doctrine deeply solidified in Georgia law for navigable streams, the final step to this bureaucratic scheme is all that remains. The proponents of H.R. 519 desire this committee to expand the definition of navigable waterways for the sole purpose of ceasing as much private property from the citizens of Georgia as possible under the guise of assuring public access to recreational fishing. The broader the definition, the more private property can be taken. Secondarily, the victimized citizens of this proposal would in no way be financially compensated for the seizure of their property. H.R. 519 has the potential to be the greatest unjustified appropriation of private property since the Treaty of the New Echota, which robbed the Cherokee Indians of their national boundaries legalized by the state of Georgia Congress and the federal Supreme Court. To expand the scope of the new term navigable would compel the public trust doctrine to override 2 centuries of established case law that has sided with the property owners. The advocates of H.R. 519 want to use the public trust doctrine in an erroneous and irresponsible way to annex citizens' private property without the slightest gesture of financial compensation. Why go through this arduous process of eminent domain when you can simply take people's property using the public trust doctrine? It's theft by authoritarian seizure and a violation of the Fifth Amendment of the United States Constitution. Let me be clear. Any expansion of the definition of navigability is a clear, contemptuous infringement of the constitutional rights of the citizens of Georgia and of the United States. I know the value of these properties more than the high material value. The owners of the properties in question who are in this room today know, just as I do, the value of the land's beauty given by God's Almighty. The value of the land's heritage often have been passed down through many generations, and the value of the development, maintenance, and labor needed to ensure the consistent quality of the North Georgia Appalachians. If you expand the definition of navigability, you will steal not only their families' lands, but potentially billions of dollars from private citizens of Georgia and condemn it to public management. Such actions would not only be unethical, but entirely un-American. In closing, ladies and gentlemen of the committee, I ask you to adhere to the principles of America of which H.R. 519 falsely claims to be attempting to promote. An expansion of the definition of navigable waterways is an injustice, void of any considerable moderation and lacking any sense of wisdom in governance. I ask this committee today to take in consideration the possibility for tyrannical overreach implied in the alteration of a codified definition of navigable waterways. I and many other Georgians see this excessive authoritarian statute as no better than the intolerable acts forced upon Americans by their despotic British overlords, which our ancestors fought and died to free us from. The desire for expanding bureaucratic power is nonsensical, deplorable, and should be in every term resisted by all citizens who cling to the fundamental principles of our great nation. Gentlemen of this committee, I encourage you to not be transformed and subdued by the very powers which you were designed to oppose. If given an inch, the government will take a mile. I appeal, therefore, first to you as a fellow citizen of this great state. Do not betray the rights, privacy, and legacy of your fellow Georgians. Overcome the desire for gluttonous authority and embody the American principles of temperance, moderation, and belief in the inherent negative rights of the people that assure against encroachment by any governmental body or unnecessary statute. Therefore, I want to ask this committee to instead consider strengthening the property rights for all Georgians. Furthermore, I'm asking this committee to introduce a bill that will ensure doctrine can never be utilized in the future or unjustly seize of property rights from the private citizens of this great state. I state this as a Georgian with sincere heart and dedication towards the preservation of our state. It's the people and the principles upon which this state was founded. Thank you for your time.
Thank you, Mr. Glenn. Deputy Turner. Mr. Justin Turner.
Good morning, committee. My name is Justin Turner. I live and work here in Fannin County, Georgia, and I'm also a veteran farmer, and I live on Coopers Creek. And if you're not from here, you may call it Coopers Creek, but that's acceptable as long as you put the S on the end of it, okay? I do thank this committee for being here. I'm glad that something that happened on the Flint River in South Georgia or wherever didn't cause a knee-jerk reaction with our legislators to pass something without asking first. So I'm glad the committee's here, and I'm glad y'all are here this morning. I wish it'd been a little bit better time if we'd had some more people here. But I'm going to speak for myself, and I'm going to speak for the majority of my neighbors. And my neighbor composition being fellow farmers and people who have had generational land, all the way to folks who they have a lot in God's country and they gave a lot of money for it so they could put a couple fish in the creek and enjoy them. All right. My first concern, and I'm sorry to have to address a concern after thanking y'all for being here. My first concern that there was like a hypothesis bias, because when I first read what was released and why this committee was formed, it talked nothing about but fishing. That's all it addressed. You pull up the Georgia Constitution and you look at that amendment, and it also mentions hunting. And that has been brought here today, and I'm going to readdress some of those things that have been said here today, because when y'all get back in front of your peers and your colleagues at the Capitol, I want you to remember what we said here in North Georgia today. I want it to ring clear. We do not have navigable water in our small streams here. We do not believe that people should be trouncing across our property. It is private property. So you can go back to the Capitol and say, yeah, those folks ain't for this. All right. But the hypothesis bias, when I first read what was released, it was all about just the fishing part that came out of the Constitution. And then there was all this, fishing does all this for our economy. That's great. That's awesome. I'm all for that. Property owners contribute to this economy. I learned something a few years ago. When our family farm became mine, man, I'm spending a truck payment in insurance and in property taxes. A lot of my friends are going to Gatlinburg every other weekend. I'm sticking around the house doing farm chores and paying taxes. And I'm not complaining because I love being there, okay? It's an honor from the good Lord. If you do let these folks on my property, are you going to give me a break on my valuation on my property because I happen to have some creek front? Will my property still be as valuable? What are we going to do for landowners when you, there's something when you buy property here, yeah, I've got a little bit of heaven right here, including the land underneath this trout stream. Never tried to claim the water. State of Georgia and the EPA came in many years ago and said, hey, you got to have a permit. If you want to run a pump to water your garden or to water your grass for your cattle, you need a permit. We gladly got the permit. We're conservationists also. So money comes from landowners. We spend money to work our farm. We spend money to keep the creek up, as far as our fencing and fighting erosion and just enjoying the creek. People spend money also. And all of this about the role of WRD fisheries management. I'm all for it. It's awesome. It's in the brochure. I'm all for these public areas. I'm all for this. Out in the public areas where it belongs. Okay. Not on my farm. All right. My neighbors don't want it in their front door. Okay. I never asked the state to stock any fish. All right. I just ain't going to let anybody come in there and fish. Now, if you gentlemen are strangers to me, if you'd stop by the house one day and we were working in the garden or sawing on some timber and you'd ask permission, I'd probably let you. But that's usually not what happens. That's not what we're seeing when we live here in the mountains. A lot of people come in here. I'm not saying not from here. I'm saying local people. They think your property's theirs. They're getting this mindset. And this public trust doctrine mindset, it's something that could get really carried away really quick and get out of control. If you can come down the creek, Cooper's Creek, all right? If you can come down the creek fishing, you're going to be stepping on my property or my neighbor's property. Unless there was just a flood, you're gonna be touching property. Okay, there is no ifs or about it. All right. So if you can come down stepping on my property to fish on Cooper's Creek under the public trust doctrine, when I leave or when I go home this afternoon, if this doctrine got carried away, not only could you fish there on my farm, on my property, but I guess you could put a tree stand in my front yard because the deer come through my front yard. So there's got to be a limit, a boundary. And that limit and that boundary has already been said about what's navigable, what's non-navigable. It's already been said. CFMs and WITs and all that stuff that's been presented, That's something the state came up with, but not my legislators. That's not the law. That's just been a guide. And this is my question. If somebody gets hurt out there in that creek because that property is in my name, who's liable? If the legislators expand access to private property, and I won't go over the Fifth Amendment, the original due process amendment, or anything like that again, y'all are very aware. You know, is Farm Bureau going to have to pay for it, or is the state of Georgia going to come in and give me some money to pay that suit? If you can come down the creek and you can go fishing, what if you want some lizards to fish with? Can you walk up the small branch that comes through my property and go up to my spring box and look for lizards? I mean, where does it end? And I know I say it over and over again, but I want y'all to be able to take this back to the State House and say, we heard it over and over again. And I'm not going to be very long, I promise. A couple numbers I want to give you. 100,000 acres, okay? Plus or minus a few. So here I am on my little farm, Fannin County, Georgia, on Coopers Creek. There is 100,000 immediate acres of public land, the Chattahoochee National Forest, Rock Creek Wildlife Management Area, Coopers Creek Wildlife Management Area. They stock them, they have water, they're public. Taxpayers pay for them, let them enjoy them. Why do they want to come down there on me? Why do they want to be on my property? And why should the state allow them to be on my property or give them the idea to be on my property? 42% is another number. Roughly 42% of Fannin County, Georgia is owned by the federal government. All right. There is plenty of opportunity without having to get into someone's private property. I'm just going to give you a day. Like I say, I speak for me and most of my neighbors. Okay. I'm just going to give you a story about one day in my life. Okay. I got the tractor running. The kids are angry because they can't go somewhere on Saturday morning because we're going to work. My dad's usually got the chains. In other words, we all working. Does that make sense? We're working on our farm to keep it running, to keep it beautiful, to conserve things. And here I am. I'm sweating. I'm hot. I'm tired. The kids are mad. The wife is mad because we missed something on a Saturday because we're doing farm work. And I'll be dang. Here I go up through the woods for whatever reason, or I go up through the pasture, and man, there's some stranger and their waders and their fishing pole. You with me? I'm working hard to keep what I got and to conserve it for all my neighbors and everybody downstream. It's not a good feeling when you work hard, whether it's direct labor, working the land, or just working to pay your taxes to have that land. It's not a good feeling to be undercut by someone who feels they're privileged through some doctrine. And we as farmers, we're conservatives. We conserve. We really care about the property. Not only is that our living, that's just what we do. When I was a kid, I would get so mad at my dad. Some of y'all are old enough to remember the droughts in the 1980s. We had several years of drought. My dad decided to make new ground, new pasture. And there was acres of rocks. And he would go to work. And my job, I was about a 10-year-old, was to walk around and put all these rocks in piles during the week, during summer break. On Saturday, he'd pull the wagon through and I'd throw the rocks on there. But do you know where the rocks went? They went on a creek bank so it wouldn't wash away. And I really thought my dad was just being mean. What he was doing was showing his love for our property and keeping it for future generations. So what we were physically trying to do for that property for the future generations, we also want to make sure that we can do ideologically and legally for my property for other generations. For my two children, and they're not hardly old enough, but grandchildren soon. You get in there with your colleagues and this public trust doctrine comes up. Some of your colleagues is going to say, you know what, those privileged folks up there that can afford a lot on the river or has some of that old family property on them creeks up there, they're going to make us out as the bad guys, especially some of your Democrat colleagues. Send them up to the farm for a day or two. There's no privilege. It's hard work. It's a blessing from God, but it's hard work. And if any of y'all really want to know if the upper Toccoa is navigable water, y'all give me a call. Next July, y'all come up to the Coopers Creek Baptist Church Annual, float down the creek and have a picnic. All right? You're going to be disappointed though. Unless there's a recent rain, even in the upper Toccoa, coming out of the Union County, Fannin County line, all the way down to Mr. Steve Sight's place at the Van Zant Farm, you'll walk more with an inner tube than you'll float. There's nothing navigable about it.
I gotta ask you something. If you'll check the record, the Democrats didn't pass this bill, okay? I mean, you need to get your facts straight there. And secondly, what's the name of your church?
That's the Coopers Creek Baptist Church.
Now, me and Matt can come and eat with you. He ain't coming.
So they're thrilled around my place. You come anytime you want to, but if it's Sunday, if you miss church, you don't get my mama's dinner. Okay?
Fair enough.
I do appreciate y'all's time. I do appreciate the committee being here. I thank y'all very much. They're probably, everybody's looking for clarification, but the clarification of the way the law stands now is already a good clarification. You can float a barge or you can't do commerce. I mean, it's one way or the other. If other people want to get together and do something else, if they want to be more allowing to the public, let them be more allowing. But my neighbor's decision or some public opinion today shouldn't dictate what happens on my property against my wishes or my desires. I should have some say so. I don't want someone standing there on the bank when I get home fishing in my creek, and I don't want to see anybody have a tree stand jacked up in my front yard trying to kill my does either. All right. I do appreciate y'all. Please consider this hard. Please remember, all these things are great. As far as I'm a fisherman. I'm an outdoorsman myself. It's all great. It's all awesome. Okay. It really is. And it generates a lot of money. Sure. But man, private property owners, okay, we have to be stood up for also. Please respect our rights, and we appreciate your consideration.
Thank you, Mr. Turner. Well, folks, that brings us to the end of our public comment, and I want to thank you again for hosting us here in Blue Ridge. This, as you can tell, is a very passionate issue, and we have had some very good dialogue here today. And I want to say and reiterate to you that this body does respect private property rights, and it would be remiss of us to not do that. I'm just like the deputy there. I don't want to walk out my back door and see somebody walking up my creek. So that's not lost on us at all. I can speak for the committee and I know that. I know their hearts. So I very much appreciate you. I'm going to give the opportunity for the committee to say some closing words, and then I'm going to recognize an esteemed senator in our midst, and then we're going to close the meeting.
All right. Thank you very much, Mr. Chairman. My name is Will Wade. I apologize for being a few minutes late. I actually had a good conversation with my son on the way to school this morning about what we were doing here today. And my last name is Wade. And I can remember being a 7-year-old boy, like my son is now, and asking my dad, how did we get our name, Dad? Well, he can only trace it back to 1711 when Mr. John W. Wade moved from somewhere in Europe, England, I'm assuming, and came to Georgia. And they settled in South Georgia. And he said, son, they were fishermen and they would get in the water, and that's how they made their living. So they were Wades. That's how the name came from Old England to America. And then I remember fishing with my dad, and I'm asking him, Dad, were the Wades good fishermen? And he said, no, son, if you was a good fisherman, your last name be Catcher. So I tried to tell that same story with my son today. But I will say this too. My dad and mom are both teachers, and I'm a former school board member, and I always appreciate research and studying and trying to understand and hear all sides. I'm at that point where I feel like after the third meeting and watching the first one from afar and attending the next two, I am thankful for the folks that are here that kind of understand that private property rights, to me, it puts us in a position, if we start undermining that, it's going to undermine so many other facets of what has made America and Georgia the best place to be. So thank you for those folks that have testified to that fact. I'm in full agreement. And given the study committee process and the son of two teachers, I think I know the answer to the question, and I'm ready to take the test. So thank y'all for being here very much, and I'll turn it over to Mr. Gunter. Thanks.
I just want to thank everybody for being here and sharing your experiences and what you wanted to tell us about the legislation. I appreciate all that. This is a very important issue, and it's coming across loud and clear that property rights are something we definitely need to consider here. So thank y'all all for being here, and I'll turn it over to David.
Thank you. I want to echo what the chairman had said earlier about, looking at private property rights. I don't think the intention here is to actually go in and take any property rights. And I know we've heard a lot today about people trespassing and deer stands and things like that. That's against the law. And that's one thing I have heard in these meetings, and I've heard in conversation that, that's an issue that's been going on for a long time. And I would encourage anybody to call our game wardens out there, because it is explicitly against the law to trespass and to hunt and fish without permission. That is a current law. And I think maybe this committee should consider part of this, if we're having that much problems out there, looking at, is the enforcement there? Because I want to make sure we separate the issue, because you can't trespass on somebody's private property. I don't think there's anybody on this committee that will wants that. And again, I appreciate the input. And as a fellow hunter, fisherman, with a little 10-year-old boy, I'm an old dad, the importance of our conservation and our hunting and fishing future and our future generations. I believe it was mentioned, we got to make sure that we're protecting those future generations and their ability to continue to do what we all passionately enjoy here as a family of hunters and fishermen. Thank you.
Hi. So I'm David Jenkins. I'm actually the one who sponsored the legislation to create this study committee. And having participated in this study committee for our 3 meetings now, I will say that myself and all those that signed on it may have worded it differently had we had an opportunity to write it knowing what we know today. But essentially, this committee, the enabling legislation to create this resolution, set this process in motion. And it's been directed by the chair and the members, and we've had a really good discussion. I've certainly learned a lot. I've enjoyed the last meeting up here talking about the sequoia and the trout industry and the tourism that's been developed up here. Again, very important discussions to have. I know in the last meeting, there was a lot of discussion about navigability on a stream that you couldn't float a log down. So it was kind of irrelevant in a lot of ways, but it was important. It's important part of the discussion. Like we've talked about a lot in this process, SB 115 was primarily a result of a lawsuit, and it was passed to protect fishing in Georgia. And I voted for it really without concern, because it applied only to navigable waters. And afterwards, with concerns from my constituent, of course, I called DNR and said, I need a map of the navigable waters in the state of Georgia. And the answer from the legislative affairs person at the time is, well, we won't have one. And I'm like, well, how do you get one? And it's like, well, you have to go before a superior court judge, and the judge tells you if it's navigable or not. So this is unacceptable. And look, I know the OCGA 4485, it's a very simple and basic statement of what navigability is in the state. And if you go around the state, a lot of people will tell you it's clear. This is clear. We don't need to be talking about this. And then they will tell you a different definition of how they read that law, what that law to mean. And we look at DNR's own criteria of what all the different things they use to decide if they're going to make public investment on a body of water, and if their agency considers it navigable for public use. And we're looking at a lot of stuff that isn't codified. So basically, my goal as a member in this process is just to tell the citizens of Georgia where they can fish and where they can't fish. And I know we're on a lot of small water up here, but this issue was born on a river that you can back down your boat down a boat ramp with a pickup truck and fire up your outboard motor and crank up your fish finder and start looking for fish. So Georgia is diverse, and I appreciate all the input, and we're going to continue working here. And whether we make a recommendation, we'll see once the committee gets to work here. But there is really no bias of this committee other than to seek clarity in Georgia law, so we can, from my standpoint, just tell my constituents where can they fish and where can they not fish.
Representative Williams.
Thank you, Mr. Chairman, and thank you all. You've been very good in your answers. You've been clear. A couple of things, and there is a big difference between Blackwater where I live and up here. I fish the Altamaha. At least I used to fish it. But the rumor down there is because you all opened the dams up here, our water level has been at 12, 13 feet for 2 years. And while you catching all these pretty trout, I have to stay home. I don't want to start another water wall, but just think about that a while. Now, I've heard you very clearly, and I agree with the chairman and others that have said that there's no member of this committee that wants to see private property rights trampled on. It's kind of sacred, and it's amazing what few generations will do, and Triple know what I'm talking about, because I was part of the fight, and we had to fight private property rights because it was extended over to hamburger places, and you're not supposed to get a sandwich because this is private property. But now I sit here with my friends from a different side of the table where we all are talking about private property rights positively, and that's good growth. And I've sat here and listened to King's grants, got a few in Liberty County, and grants of 1863, got a few in Liberty County. But the interesting thing is my folk were just like the Cherokee. We didn't get none of the grants. So isn't it interesting how now we're here fighting for the same thing, and we were never at the table to get any of this beautiful property that you can trace back 5, 6, 7, 8 generations. Just feel me like I'm talking. It's good when we can make the circle to be on one accord on a common issue. But let's not forget, while it moves me to see the gifts we've got that we found from the Cherokee, let's never be happy about the Trail of Tears, because that's real. And that same pain extends to the 30% of folk that did not get in on 1863 land grants. But I'm with you now. Plus, your trout's pretty good. So you've come bearing gifts, and I have gladly accepted your gifts. Your hospitality has been fantastic. It's really been great. And I don't get to come here often, but I'm going to come back again, because Stan Gunter has promised to take me on a ride through the ups and downs of the mountains. That should be interesting with a Flatlander. Thank you very kindly.
Thank you, Mr. Chairman. Thank you all for having us up here. Thank you for the comments that we've heard. I've learned a lot since I've been here. I wasn't able to make the first 2 meetings. I asked Mr. Chairman to forgive me, but they kept me up all night last night, kind of
Working out his forgiveness.
but they brought me up to speed about what the issues are here. And I've learned a lot about navigable and non-navigable waters. I've been touching Rob and asking him things since everybody was speaking. But all in all, your hospitality was great. We enjoyed seeing your property on last night, beautiful property. Also, this property here, we enjoyed seeing it today. Your hospitality has been great up in these mountains. Speaker Ralston used to always tell me about the mountains up here and how beautiful they were, and they are beautiful. But I'm like the rest of the representatives. I don't think anybody want to infringe on private property, your private property rights. And to be on this committee and to see what comes out of it would be an advantage, I think, for everybody, because you should have private property rights and you should protect those. So thank you all for having us up here. Excuse me. Having us up here in your hospitality, for being here. And Al Williams is the only one coming back to the Baptist church. I've already got my schedule filled out. But again, thank you. And God bless each and every one of you.
Thank you, Mr. Chairman. Just want to thank everybody for your the time you put into this and your passion. I will say I can understand the concern from some of the language in the House bill that creates the committee, but I sense there's a concern. Certainly, a concern I have is to make a change to a statutory definition that would potentially upend really old Georgia case law governing ownership of property, and thus would effectively change some established rights. It's certainly the expectation I think a lot of folks have. So I'm certainly sensitive to that, and I appreciate your comments. We heard all this in Clarksville last week, and it's certainly good to hear it again. So I appreciate everyone's time and passion on the issue. Thank you. Thank you, Mr. Chairman.
Thank you. And we did it, folks, 11:31. And it'll take only one senator to push us over the limit. So I'm gonna relinquish the podium to the fine senator and leader, Senator Gooch.
Now, up here on my microphone, there's a clock that says 53 minutes remaining. Is that
negative?
Is that correct? Talk all day. I'm standing between you and lunch and you and a plane ride back to Waycross, so I'll be brief.
Yes, sir.
If you want to go home, see your son play football. First of all, thank you all, gentlemen, for being up here in North Georgia in God's country. We are blessed to have a beautiful place to live and to call home. If you look out this window, you see these beautiful vistas and these mountains. But these mountains are filled with independent people, Appalachian folks that have earned the right to live on their land. They pay a lot of taxes on that land. They come up here to settle, whether they were born here generations ago or just moved in, like many of those that are coming. But they're very independent. They want to be left alone. For the most part, they don't want government intervention in their lives. You all know that. These people in this room feel the same way. I represent three of you here in the room as your senator, Stan Gunner and Will Wade and Johnny. And I can tell you that we've fought some of these issues in the past. This isn't the first time property rights have come up. 23 years ago, I was elected as the sole commissioner in Lumpkin County, where I live. I was at the ripe age of 32 years. And at the time, we were beginning to construct a water reservoir for drinking water. Everybody thought we needed to have plenty of water for future growth, so it seemed like the right thing to do. After we built the reservoir, we found out quickly we couldn't get water out of the reservoir without a permit to withdraw the drinking water, so it seemed like a pretty logical step. When we started to apply for the water withdrawal permit, we were told by the state EPD we would have to implement watershed protection measures before we would be given that opportunity to use that water that the state claims to be theirs. Once we dug into that, we found out quickly that that was going to be a problem. They wanted us to take property rights away from the landowner 7 miles upstream of the water intake, 150 feet on both sides of that stream. So people own land on both sides of the creek, or on one side of the creek, you pay taxes to the center of the stream, and you own that land for your entire life, or maybe for 2 weeks or 2 years or whatever. We were told we had to go in and set up a undisturbed buffer which is basically the width of a football field, 300 feet, upstream 7 miles. That that was not only for that main stream for that reservoir, but for every tributary coming into those streams. So we quickly discovered that wasn't going to happen. Just about every landowner in Lumpkin County came out ready to fight, and I joined them. We've said no, hell no, we're not doing this. We're going to find another way. Well, we never found the solution until I became a state senator, and I fought to get into the Senate, and that was one of the issues I fought for, was to protect the private property rights of people in Georgia. We changed that law about 2 years after I was elected, so now we no longer are required to take people's property rights in order to protect the watershed. There's other ways to do it, and what we discovered over the years is it's not a one-size-fits-all approach. You have to find other ways to get things done, and we did that then. Now, you're the lawyer from the Southern Environmental Law Group. We've crossed paths with your organizations in the past. One thing you said earlier about how much different Montana is than Georgia was true, but there's also some similarities in Montana. How many of you have watched the TV series Yellowstone? So my two favorite characters is John Dutton and Beth Dutton, right? Absolutely. So Blue Ridge has several John Duttons running around up here in North Georgia, and we also have a few Beth Duttons. They're pretty good with a 12-gauge shotgun, and we also have a train station. Those of you that have watched the TV series, you understand what the train station phrase is. So be careful if you're trespassing up here in North Georgia. You may end up going to the train station. Thank y'all for having me today.
Thank you, Senator. And I've extended this invitation at every meeting. I'm not going to stop now. Each and every one of these members has a card and contact information. If you want to continue the conversation offline, that's perfectly fine. We anticipate that to be the case. Getting up and talking in front of everybody is not everybody's thing. So please feel free to reach out to us as we continue down this road of studying this issue. And one last time, I want to thank you for your hospitality and thank you for your words today and your testimony. And with that, I'm going to adjourn this meeting. Thank you.